But with respect to item number 9 of today's list, original site, I was beseeching your lordship to kindly fix up the matter at a particular time if possible.
Sorry. Yes, next. Sorry.
Appellate side mentioning with the leave of Honorable Justice only for my lord may post innocuously prayer must be compared to the court. It's the second that we, my lord, which has been assigned to your lordship. My lord, my client is a senior citizen, 80-year-old citizen. As your lordship seeks singly kindly, my lord, takes this matter, my lord, will seeking for relief.
It will be listed, sir. Give the number. I can't promise you.
But I understand, my lord. But for inclusion, it's here English matter.
When was the order passed?
27.
Order. 2nd February. When did you apply for certified copy? 4th February or March? 4th March. Declined.
We have your kind leave to mention one application, review application for inclusion in the list. Your lordship.
This bench.
This bench, your lordship. Very urgent matter, your lordship. The demolition drive is on.
Which matter is not urgent? Point out one matter in the list which is
Please,
not
your
urgent.
lordship, passed our order.
Give it.
Kindly appears it tomorrow. Direct the matter to appear tomorrow.
Call the list.
I'm for the respondent.
Pass over.
One of the respondents. I'm for the 7 and 8.
अरे appellant नहीं तो. 3.
2. He's the appellant. As for some of the respondents.
You are?
I'm for the KMC.
You are for?
10, 12 to 16.
So all parties are here, Mr. Good.
All are.
No, all respondents probably are not there anyway. Most of them are here. All the respondents do not sail on the same boat.
The tenancy should be vacated. Some of the tenancy they are contesting. Corporation.
Mr. Ghosh, your affidavit of service is ready?
There is an incomplete service. I have not been served with a memo of appeal. And my grievance is abuse of process of court and fraud on court.
Memo of appeal was a different thing. Or the state petition he has received.
But memo ought to be served. Grounds of appeal should be made available, Mr. Ghosh. Kindly ensure full service, complete service, because I don't think all the respondents are here also. You kindly satisfy yourself that all the respondents have been served. After that, whether they appear or not is their problem.
That's right, Melody. Actually, one of the London Junior.
We'll pass it over then. We'll pass it over.
All the private respondents are present.
No.
All private respondents.
No.
I am for 7 and 8.
And 10, 12 to 16, so 11 is missing.
11 is missing. Yes.
Number 4.
My lord, item number 4, I am for the petitioner. I am for the contemner number 1 will file the report.
Lordship, I am for the contemner number.
देखिए, title देखिए. Oh, so now you have included a toxicologist.
Lordship, there has been a development in this. Arijit Medical College, their toxicology we had pursued with him. He has reported that particular instrument what is required for measuring the toxicology, for doing the experiment with the toxicology report of the brain is not available. Therefore, the director of the health services has forwarded a request to the Ministry of Social Justice, to the company, to the authority who is manufacturing braille, whether that to update us that whether there is any toxic present during the process of manufacturing braille, or there is any toxins presence is there in
Yes.
the presence of the toxins can be determined only by the.
Are you submitting a report today? Are you filing a report? Whatever it is, whatever the development is, you were directed to file a report.
Yes, my lord.
You are appearing with
Lordship,
Mr.
I am
Srikanto
for the
Dotto.
petitioner. I am for the petitioner.
You are appearing with Mr. Srikanto Dotto.
Yes, I am appearing on behalf of Srikanth Rath. He has not come to the court today, and that's why I am appearing on his behalf. And my lord, kindly give in a not today or something like that. And if the contempt number 1 already files the report, kindly give.
I express my sincere apology
Come back tomorrow with instruction, not today.
because I'm not able
Not
to find
today.
out the report.
Grateful, my lord.
Much obliged.
Yes, Mr. Ghosh.
I am for the not respondents, my lord.
We are being led by Mr. Utpal Mujumdar. He's appearing online for the writ petitioner
This is
respondents.
Kushtia Road.
Yes, yes, Your Lordship.
This has to be heard out now, Mr.
Yes, Your Lordship.
It's an appeal to be heard, my lord.
Mr. Ghosh was here. Pass over, pass over. He is appearing for the KMC.
Yes, Mr. Ghosh was appearing.
Pass over.
Your Lordship, Mr. Ghosh is here.
7.
Your Lordship, Mr. Ghosh is
For that matter, Mr. Shandal.
We heard of.
Mr. Mujumdar is here, no? Pass over.
I think he's come. His junior's here.
I am here, my lord.
Call, second call. Second call, Mr.
9, I am for the respondent, my lord. You just mentioned item number 8, 9. 9.
10, 11.
10. রেসপন্ড করলেন না কি বললেন আমার তো প্ল্যানটা দেওয়ার ছিল
Yes. Yes, item 1, Chilo, appellant first. You are for the respondent. In the first call, appellant was there. No. Usual order, Mr. Sen. In Bengali, it is called Ghochang Pu.
matter is being regularly heard in the trial court.
Dismiss. Bakatsu কেন? জানো না?
Item number 1, praying for short passover, Mr. Chakraborty.
What passover? It's very well. Now,
This is better for us. My lord, কে বাঁধাটা কোথায় গেল? Lord, I beg to appear on behalf of the appellant. My lord, the writ petitioner private respondent herein, my lord, filed their writ.
বিশ্বাস.
Yes. for the writ petitioner filed their application before the my lord, court below. My lord, number of interim order have been passed by this honorable court. My lord, I am at the outset I am drawing lordship attention. My lord, why at this interim stage I am before this honorable court?
7th February order.
Yes, my lord. Why?
What is there?
Number of orders are there, my lord. Lordship, kindly see page 37 is my prayer portion. My lord, the order which is,
How is 7th February order appealable?
my lord, because of it is available, because of that reason, we are on the number of occasion trying to draw the attention of the honorable court. My lord, they are praying for implementation of an order which is in view of the Kolkata Municipal Corporation, very clear statement before this honorable court, non-est in the eye of law. My lord, they are asking for demolition for an order against that particular order. My lord, that order is no more, my lord, it is not in existence, my lord. That is why I am trying to show, my lord.
Trash that out before the learned judge. Why
But
should we interfere?
on number of occasions, my lord, I have drawn lordship attention. Only one indulgence, my lord. Only one indulgence.
Mr. Chakraborty, this order, please don't press the appeal.
My lord, my lord, the authority, my lord, honorable court was kind enough to direct different authority to do fact finding for implementation of an order which is non-est in the eye of law. That order has been recalled by the Kolkata Municipal Corporation. They have very categorically stated out of misconception.
That canal
Yes, my lord. Yes, my lord. One contempt for implementation, contempt is also pending, my lord.
Very good.
That is why kindly see, my lord. My lord, kindly see, my lord. Kindly see, my lord. I may be allowed page 65 for a while, my lord. This 30th December 2021 order, whether is in force for implementation or not, that is required to be ascertained, and division bench, before the honorable division bench, they are, my lord, very categorically Kolkata Municipal Corporation admitted that particular order was passed out of misconception. That is non-est in the law. I'll show, my lord, for a while, my lord. 5-10 minutes time I kindly be given, my lord. Kindly see page 65, then my lord, page 80-81. 80-81, my lord.
Chakraborty, what is the order you challenge? What is
My lord, the order
made by this court, please?
Yes, my
What
lord.
is the order? What is the order?
I'm reading, my lord. I'm reading. My lord, the order dated.
Simply it is director.
Yes, my lord.
To
True.
file a report.
Not only one authority. Prior to that KMD.
To read the order and satisfy us.
My lord, I'm ready. Kindly come to, my lord, the 7th February order. A report has been filed before this court by the learned advocate representing the corporation, signed by the sub-assistant engineer, assistant engineer, civil, so and so. On a perusal of the report, it appears that the same is not in a complete one. The corporation is directed to provide a complete report with definite finding with regard to the existence of premises number 76 and 84. That was already ascertained. And on
Want to set aside this order?
my lord, this is standing on the way.
The order you challenge in the appeal.
True, my lord. That this is the order. On the basis of that order, Kolkata Municipal Corporation once again undertaken, my lord, the inspection and trying to file their report. And my lord, which was previously concluded, on the basis of conclusion, order has been passed, and they have categorically stated before the honorable court that order is non-est, and my learned friend is trying to implement that particular order. For ensuring implementation of a non-est order, all these exercises are taken into consideration by the honorable writ court. Not only this, another number of orders are also there.
Before the appellate forum.
True, my lord.
Before the writ court.
True, my lord. True, my lord.
There and answer.
True, my lord. No, my lord, the only thing is, my lord, that question is required to be decided by the honorable writ court first, my lord. That permission may kindly be given. My lord, we have drawn attention of the honorable court on number of occasions. Honorable court was on different occasions, once, my lord, to KMDA, once KMDA, then estate acquisition, then, my lord, the Kolkata Municipal Corporation for implementation of an order which is in terms of the KMC submission non-est in the eye of law. That is on page 80-81 may kindly be looked into for a while, my lord. 80-81. My lord, I'm just reading what KMC had said, my lord. And Lordship 80-81, Lordship, kindly see the order dated 30th December 2021. This order was passed by the Kolkata Municipal Corporation, and we have immediately challenged it. Honorable writ court directed us to approach, my lord, the tribunal. Then, my lord, before this honorable court, then, my lord, this honorable court, page 82, directed to file a report. Then, my lord, kindly see the report. What is in the report? Lordship will find, my lord, from the report that out of misconception, my lord, they have done all this. I'm coming, my lord. My lord, kindly see, my lord, page 181 for a while. 181. My lord, in the year 2004, my lord, the unauthorized construction related, my lord, the order has been passed. Page 81 for the self-same premises. At that point of time, my premises has been termed as B by 76 by H by 23. There are 3 premises. All property belongs to the Thika, and I am a tenant of that property. And in the year 2026 to 2004, this order was passed. And only, my lord, I am to take one, my lord, no objection from the Thika controller. This honorable court directed Thika controller to look into the issue and passed order, and thereafter passed order. When this matter was, my lord, considered at the very outset, my lord, what happened? Lordship directed them, my lord, to file the report. Lordship, kindly come to the report. Page 227 may kindly be looked into then, my lord. Page 227. My lord, in the second order, when the report was available before this honorable court, page 225 to 227, corporation, my lord, said once a decision is taken by the Thika controller, the Thika will act in accordance with the law depending whether or not the Thika controller has issued no objection certificate. And my lord, page 224, 223 and 224 is the report. Pursuant to the direction issued by this honorable court, 223 and 224, my lord, I'm reading. But the office of the KMC, upon misconception, proceeded to treat the, my lord, the retained construction as unauthorized for failure to comply with one of the condition. My lord, initiated another demolition proceedings in respect of the self-same unauthorized construction. My lord, 30th December, the order was passed. Subsequently, by filing report, there are very categorically stated that order is non-est in the eye of law. Then, my lord, I am showing, my lord, that this particular, my lord, the observation has been recorded by this honorable court. That I am showing, my lord. After the report was placed before this honorable court, and they are asking for implementation of the order of 30th December 2021. But I'm coming, my lord. From the second order, my lord, page 117, my lord. Page 117 says, my lord, let a spot inspection be conducted by the surveyor from the department of the chief valuer and surveyor. At that point of time, my lord, this was taken into consideration, my lord. And my lord, this observation was recorded in the case, my lord, the order of this honorable court. And on the basis of that order, my lord, the Thika controller has passed the order. Now, my lord, our humble submission, when the order is non-est in the eye of law 30th December, my lord, they are asking for implementation of the order of 30th December. And for that, my lord, this exercise has taken into consideration by the Honorable Lead Court on number of occasions, directing the KMD authority.
Very well. We have heard you in long enough, Mr. Chakraborty. Come. This appeal is directed against an order dated February 7, 2024, passed by a learned judge of this court in WPO number 1533 of 2023, being a writ petition filed by the respondent number 1 herein. Stop. The order impugned reads as follows. A order to purotai set out. Memo theke. Paragraph. By the order has decided nothing. Stop. It has only directed Kolkata Municipal Corporation to file a complete report with a finding with regard to the existence of the concerned premises. Stop. This order is not appealable under Order 43, Rule 1 of Code of Civil Procedure. Stop. By no stretch of imagination can this order be said to be a judgment within the meaning of Clause 15 of the letters patent. Stop. Paragraph. This is a misconceived appeal. This is a misconceived and frivolous appeal, bordering on abuse of the process of law. Stop. The appeal is dismissed with costs assessed at rupees 30,000 to be paid equally to the respondent number 1 and KMC, comma, within a fortnight from date. Stop. তারপর they have to জিজ্ঞেস করে নিও, let a copy of the in the event, in the paragraph, in the event the cost is not so paid, comma, both KMC and the respondent number 1 will be at liberty to mention the matter before us for appropriate direction.
True, my lord. Only one thing, my lord. Only one thing, my lord. Liberty may kindly be given, my lord, to before the writ court, my lord, to draw writ court attention, my lord, regarding, my lord, our contention. My lord, 30th December order is non-est.
It's a misconceived appeal.
True,
You
my
can't give any direction.
My lord, I am not opposing, my lord. The costs have been imposed, my lord. Lordship is come down heavily, my lord. But the thing is this: they are asking for implementation of an order which is
Sir,
non-est.
Chakraborty, final, let the learned just decide something. Come up before us.
Well, this particular decision is already taken previously
How do we know?
when the division
This
bench matter was
before
pending.
us. No.
Deep love. Deep love.
I am for the appellant. But if it is because the notice of motion is there,
Yes.
therefore more the parties have been served.
Only one respondent was missing, probably. 11.
But they make a service করেছে তো। Everyone has been served.
Mr. Ghosh, please satisfy yourself. We'll take your word.
But I am just one of the inquiring from my learned junior. I have not personally checked it. I have no doubt about that. But in the
If you tell us everybody has been served, we will take that word as final.
11 के सर्विस document
You just satisfy yourself that the respondent number 11 has been served. The others are represented. Yes.
my advocate record my says, my lord, the gentleman, the lady, my lord, the 11, 11 has not taken the copy.
But the affidavit of service should say that.
Every service, notice of motion, every service, বলেছে নেয়নি বলে, and it has not been done. Notice of motion is there, but every service has not.
Do it. It's a simple thing. Just come back tomorrow.
My lord, I want to file affidavit.
What affidavit? Let us see the order first.
My allegation is fraud on
This
court. I
is
want to
not the
rely
issue
upon
of
certain
this is not
documents.
the issue of my lord, filing affidavit, because the court has not entertained my petition on a particular reasons. My submission would be whether regarding the entertainment of the writ application, I have come to my lord that the for failure to discharge the statutory obligation on the part of the authorities of the corporation, for that reason my petition has been filed.
We will consider it. You come back with
My
proper affidavit of service. If you want tomorrow, if you want Monday, choose your day. Reach of your statutory duty, Mr.
I
Mukherjee.
have to rely upon certain documents which is not a part of the record. So I'm filing.
Sir, we have to consider. Let us apply your mind first. When?
Tomorrow,
Tomorrow. Lekho.
Monday, let it be.
Monday.
Why? Tomorrow, what is your problem?
I have certain
Engagement.
engagement. I have to attend a rather ceremony.
Oh, Baba. Service
My personal difficulty.
on respondent number 11 has not been effected as yet. Stop. Let the matter stand adjourned and be listed again on Monday date the other. Stop. Proper affidavit of service will be filed by the appellant on that date. Better matter. 1 second, Mr. Chakraborty. One second. Yes.
My lord, here also.
All
my lord-
parties here? I mean, you have served everybody.
Yes.
Affidavit of service?
Affidavit. হ্যাঁ, আছে তো। Well, my learned friend along with my learned senior is there.
Any private respondent?
Yes, my lord, so for respondent number 4, Hindustan Petroleum, I am agreeing on.
My lord, this is a case, my lord, protracted litigation. And my lord, what happened? My lord, small order passed by the Honorable Reed Court, 141.
Yes.
My lord, kindly come to page 96. There was an agreement between, my lord, the predecessor in office, my lord, present appellant, my lord, stepped into the shoes of erstwhile owner. Here is, my lord, an agreement for lease for 10 years initially. Then, my lord, extension renewal for another 10 years.
Lease by whom to whom?
My lord, lease by one. Page 96 may kindly be looked into. This is, my lord, kindly come to page 95. Standard Vacuum Oil Company.
This was the predecessor of interest of
Yes,
Hindustan
yes,
Petroleum?
yes. My lord, this is for 10 years and 10 years. 10 years initially. Extension page 96 may kindly be looked into, my lord. Second paragraph, bottom, to hold the demise premises unto the tenant from so and so in the for the term of 10 years. Lordship got it? Page 96, second paragraph.
Yes.
Then, my lord, kindly turn to page 97, para 3, my lord, D. D, my lord, once again 10 years, last two line, for the term of 10 years from expiration of the said term at the same rent and containing the like covenant and provisions are herein contained. But total 20 years, lease executed in the year 1949. My lord, that is in the page 96 at the top. Then, lordship, kindly come to, my lord, page 106. My lord, I have purchased the property. My name is appearing in page number 102. Schedule is 106 of the said property. And mutated my name, my lord, in the register of Kolkata Municipal Corporation.
As the owner?
As the owner.
You purchased from Tollygunge Estates Limited?
Yes, yes, my lord. My lord, no dispute regarding all these things. Then, my lord, kindly come to the first round, my lord. Litigation, page 120. My lord, the Honorable Reed Court was kind enough to observe this is such a matter which is required to be adjudicated by the appropriate forum, not by the Kolkata Municipal Corporation. Page 120, 121. Being aggrieved by, I preferred one appeal before this Honorable Court. Honorable Court directed, my lord, page 124, this Honorable Reed Court, appeal court, my lord. Last two paragraph, we are of the view, page 124, lordship. We are of the view, since a representation has been made by the appellant, there will be no harm in directing corporation to consider and dispose of the same in accordance with the provision of law. Then, my lord, Kolkata Municipal Corporation acted. Page 126. A hearing was there. My lord, our presence has been recorded. Upon hearing the verbal submission, middle portion of the 126, annexure P8, and going through the petition as well as submitted document, lease agreement between Tollygunge Estate Limited, Standard Vacuum, then, my lord, KMC tax receipt, Chika return, challan submitted by the HPCL, along with the written submission. Then, my lord, it is found that the lease between the Tollygunge Estate Limited and Standard Vacuum Oil Company commenced on so-and-so 28/7/1948. Though the lease was registered on 25/5/1949, expired on 27/7/1968, after 10 years renewal. Monthly rental was 135 PM. HPCL could not produce any cogent document like extension of lease, agreement of tenancy, or any other competent authority for adverse possession for holding over the same in respect of the possession of the subjected premises. However, the submitted a miscase was lying pending before the controller, Chika, West Bengal, under section so and so provision, my lord. My lord, this was recorded by the Kolkata Municipal Corporation. It was ended in the year 1968. And my lord, the HPCL at the time of hearing fails to produce any scrap of document in support of their, my lord, the lessee status. Page 128, my lord. Next portion, ordering portion. Sri Shumon Saha, through his advocate so and so, before the chair, that the Messrs HPCL should not be written in the document of KMC as lessee. Well, this is our only prayer. So it is hereby ordered that the name of HPCL should be recorded as occupier in the KMC assessment roll.
Yes.
They are agreeable to record his name, his exact status. If anyone is tenant in the corporation record. Assessment from accordingly department will make a reading note in the inspection book regarding the miscase lying before the controller of Chika tenancy.
Mr. Chakraborty,
Lordship.
let us understand. What proceeding is pending before the Thika controller?
Well, they are claiming to be the Thika tenant and it is adjudication to be made by the Thika controller.
Correct.
Yes, my lord.
If they succeed in that,
Lordship.
then their name will be recorded as lessee?
No problem, my lord. We are not going to stand on the way because unless it is challenged before the appropriate forum to change it. Now, my lord, the present position is they are not the lessee, they have recorded it. But effect was given from 2017 to 2018, not from 1968. My lord, municipal corporation assessment roll is not a public document. For the purpose of the present status and all these things, my lord, it is recorded and who is person liable to pay taxes. Person primarily liable, person liable to pay taxes. Now, our humble submission KMC is agreeable to record the name of the HPCL as occupier, but fails to record it since 1968. Though they have admitted in 1968 lease expired and HPCL miserably failed to produce any scrap of paper in support of their contention that they are lessee so far the premises is concerned. Our humble submission before this honorable court, let their status be recorded in the Kolkata Municipal Corporation.
Leasehold interest is also some kind of a title. It is a question of title. KMC cannot decide question of title.
We are not going to say.
So today, this assessor collector has said, let the name of HPCL be recorded as occupier.
Yes, my lord.
Now you are insisting that should be with effect from 1968.
So, my lord, how, my lord, the assessor has recorded their name from 2017, 2018? I put this question to myself.
Now, today, I don't think anything else should be done. We should await the result of the proceedings before the Thika control.
No, my lord, then also this order is bad. 2017, 2018 corporation already recorded as occupier, not as a lessee. If that be so, my lord, if this honorable court kind enough to wait for the outcome of the Thika controller, then, my lord, this particular order, my lord, is a bad order.
Therefore,
should not be done. Pursuant to the direction, my lord, to reconsider it, they have done it. But they have done it since 2017-18.
Whether it should be done from 1968.
Because, my lord, document shows man may lie, my lord, paper cannot.
No. In law, there may be no document. In law, the effect may be holding over, maybe there, this and that. We don't know. All these things have to be adjudicated.
No, my
in a summary manner, we just can't say because they could not produce any document showing that they have any right to hold on after 1968. These questions can't be decided like that.
Once again, lordship,
either we have happy with what has been done or even this we will undo.
No, only one thing may kindly be, my lord, considered. Yes. Page 128, my lord, once again.
Yes.
But it is hereby ordered that the name of Messrs HPCL should be recorded as occupier in the KMC assessment form.
Yes.
Accordingly, department will make a reading note in the inspection book regarding the miscase lying before the controller of Thika tenancy. They are well aware. And reading note was there. We are happy enough. In the event, it is a reading note endorsement in the municipal assessment register.
What does that mean?
My lord?
What does that mean?
My lord, another proceedings is pending to aware corporation person and all these things. This particular endorsement has been made. We have no objection so far this reading endorsement is made. If made, my lord, if it is made, if it is possible since 2017-18, my lord, I put this question, what prevented them when papers and document, they are not disputing since 2019-68, they are, my lord, occupying these premises in the same fashion, in the same capacity. One more thing, my lord, before my argument of my learned senior friend, lordship, kindly see, my lord, page 130, this reading, my lord, correction, page 130 in the assessment book, my lord. My lord, kindly see at the middle portion, miss case lying before the Thika controller. The middle portion, lordship, got it?
There is no red ink.
Here, my lord, in the corporation book, it is red ink, my lord. My lord, kindly see at the corner of this particular page, my lord, as per order of the Honorable Court, so and so, so and so, so and so. And my lord, here this entry has been made pursuant to the direction, my lord, for reconsideration considered by the Kolkata Municipal Corporation. Then only, my lord, they have done all these things. Now, my lord, kindly see, the Kolkata Municipal Corporation rejected our contention for the reason, my lord, 137. My lord, kindly see, my lord, when we apply before them, kindly do it from 1968. What was the reason, my lord? Page 137 at the bottom.
So this 137 you have challenged before the learned single judge?
Yes, my lord. Yes, my lord. The grounds taken by the Kolkata Municipal Corporation is interesting. My lord, page 137, bottom, my lord. That's it, got it. It is also pertaining to mention that in our order, WPO number so and so, by Honorable Justice Amrita Sinha, has categorically stated the court is of the opinion Kolkata Municipal Corporation will not be the appropriate authority to adjudicate whether the private respondent is a lessee or not. That was, my lord, modified by this Honorable Court. After modifying, directed Kolkata Municipal Corporation to look afresh. On the basis of fresh looking, my lord, this particular rating entry was made in the assessment register. So, my lord, this cannot be taken into consideration, cannot stand on the way as a stumbling block. So far, my lord, doing, my lord, further correction. Kindly see, my lord, page 137, bottom. This cannot be the reason, my lord. This is one aspect. Turn to next page, my lord, for a while. Inspection books are textual message, textual image of inspection done by the inspector in a particular time. Altering this document bears no value as several certified copy of those already processed by the both conflicting parties. So what prompted them to do all these things from 2017-18? Meanwhile, 19, 20, 21, 23, number of persons, my lord, obtained certified copy. So that cannot be the reason. Over and above, lordship knows this is not a public document. This is a document for the purpose of realizing tax from the person who are primarily responsible.
What does this mean? Shumon Shaha is a beneficiary of HPCL?
He's the dealer, madam.
Oh.
Hindustan Petroleum appointed him as the dealer to run the retail outlet from that particular site. Madam. He's the licensee.
So that our humble submission, rejection ground cannot be considered at all, my lord. This cannot be the ground for rejection. And my lord, our humble submission once again, my lord, by this honorable division bench of this honorable court, my lord, number of occasions reiterated, my lord, the assessment book and my lord, the inspection book are not the public document. So for changing there with this reading or all these things.
Still running the dealership business?
Yes, madam.
You don't want to run it? Cancel the dealership.
That is not the subject matter, my lord.
Cancel the dealership.
That is not.
If your lordship allows, my lord, may I submit, my lord, that 2017 is not material. Your lordship knows that so far as Thika tenancy law is concerned, my lord, I have to prove that we are in possession of the land and we are the tenant at a particular time. That is when the Vesting Act came into force.
Sir, what he is, Mr. Chakraborty, is saying, if Kolkata, this Mr. Ghosh will answer, if KMC says, the assessor collector, that with effect from 2017, record the name of HPCL as occupier, not lessee, then why not from 1968?
I am aggrieved. So, in the event, if, yes, I am aggrieved if the effect is given from 1968 or something prior to that, my lord. In view of the fact, since section 5.3 proceeding is pending, before the Thika controller, I will have to prove, so far as definition of Thika tenancy is concerned, my lord, that I am a Thika tenant over the property.
You better than, no, 1 second. Before the learned single judge, no affidavits were filed.
No.
Would you want to file an affidavit, Mr. Ghosh? To bring on record your case, that is all.
It may be done.
This is no cause prayer, my lord, before this honorable court.
What?
17-18 done already, my lord.
No,
papers, so papers, man may lie, my lord.
Let them explain why they have refused your prayer. Let them explain
No,
that.
my lord, this is the explanation as to why they have refused page 137, 138. My lord, whether this can stand on the way My lord, kindly see, my lord, the judgment passed by the earlier round by the writ court
File
has
a,
been modified.
file a short
Has been
appeal.
modified.
The
Then
this
over
appeal-
here, my lord.
appeal is directed against a judgment and order dated February 5, 2024, whereby the appellant's writ petition being WPO 25 of 2024 was disposed of by a learned judge of this court. Stop. Paragraph, the writ petitioner challenged an order of the assessor collector, Tolly Tax Department, dated December 11, 2023, rejecting the writ petitioner's prayer to rectify the old inspection book. Stop. The learned judge noted that a proceeding is pending before the Thika controller regarding ascertainment of the right of Hindustan Petroleum Corporation Limited
Whether it is a Thika tenant or not.
as Thika tenant of the property in question. Stop. The learned judge observed that the learned judge disposed of the writ petition with the following observations. Internal page 2 theke. Paragraph being aggrieved, the writ petitioner has come up by way of this appeal. Paragraph. Affidavits were not invited by the learned single judge. Stop. It may be helpful if Kolkata Municipal Corporation and Hindustan Petroleum Corporation Limited put their stand on affidavit. Stop. Paragraph, let affidavit in opposition to the stay petition be passed, be filed 1 week.
My lord, I will have to get it dated.
Within 2 weeks from date ta diye dao, stop. Reply thereto, if any, be filed within 5 days thereafter. Date ta diye dao. Paragraph lists the matter 3 weeks hence. Date ta diye dao. Under the same heading. Under the same heading.
No paper.
Not necessary.
Deep
You want to file paper book?
No, but for the convenience of the
I got a puzzle.
কেন তাহলে? কারণ তোমার মনে ছিল না। Appellate side. This we have divided the time because second half
Because second half, tomorrow possibly will be division of the original side appellate side, because Your Lordship has given a note that from 2 o'clock
appellate side hearing
matters, especially fixed and hearing matters will be taken.
My lord, the original side matter will not be taken now.
Your Lordship, Mr. Mojumdar is online. He's leading us in the matter.
My lord, the original side matter will not be taken anymore.
No, not today.
Not today.
There's a note in the appellate side. You don't study the list, madam. That's the problem. Before reading your brief, you should read the list, cause list. That is what late Mr. P.K. Das taught me.
Not today, Your Lordship.
Not today. It will remain in the list, just like it is. Your report is still not ready.
Yes, my lord, report has come. But
It's come.
already come. But it has not been clear, actually.
What is not clear?
Well, not,
Whatever report has come, you file.
well, let it be fixed another date. Well, I will file.
Why today is a bad day?
No, not that, not that. No, I was not in a position to come with the brief.
Interim order is expiring when?
February end, expired.
Oh,
That is,
Lekho. The business of the court did not permit us to take up this matter for hearing and disposal. So the interim order that was passed, expired by efflux of time on February 29, 2024. Paragraph, let the interim order stand reinstated and continue till the end of March, 2024. Paragraph, list the matter under the heading specially fixed matters. Monday did the other.
Only one request, my lord. Your lordship is subsisting order is that my lord, it will appear 3-4 item of this special fixed matter. Already that order is there. We will get a chance, my lord.
Look, now we have given a note on Friday, second half, we'll take up hearing matters, which means it will start from specially fixed. No, but your matter, tomorrow you want it, can you come back tomorrow? Monday. Very well, Monday.
matter will be listed on tomorrow, my lord.
Monday.
Monday.
My lord, within 3-4 matters on a special fixed matter.
Within the first five items.
Who is also same.
Same, simply adjourned. Uta action. No.
Tu क्या अलग कर दूँ? Tu क्या अलग?
My lord, I appear on behalf of Eastern Coalfield. This is an appeal from an order. I'll tell you.
Mr. Bose, first ascertain if all parties are here. The practice of this court is first call, irrespective of whether you have served or not. Unless all parties are there, we pass it over.
I'm sorry, sir. I'll wait.
Yes. Second call, if you show us that you have served, doesn't matter who appears, doesn't appear, we'll take it up.
No, even then your lordship might give notice. My lord, I'm sorry, I didn't. No. I'll wait.
No problem.
I am not the petitioner respondent number.
You are for the private respondent.
For the appellant lordship.
You are for the private respondent. Are there official respondents also?
No, my lord. No, lordship. State is the appellant. State is the appellant lordship, and
you are for all the respondents. Give it.
And there was a direction for filing supplementary affidavit.
By whom?
With by the state. With a liberty to the other
delay.
side to file response. Lordship.
7 years.
Have you filed?
7 years.
5 years.
We have already met. Lordship, may I put on record, Lordship? We have served upon the other side, my lord. There was a liberty. You don't want to use any response. Oh, my learned friend is not willing to use any affidavit, Lordship.
You're not using any affidavit.
Because my client is bail detained, he is not able to come. Let it be disposed of if your lordship thinks fit without any affidavit reply in respect of the section. Or kindly take up this matter.
Lordships, may I respectfully submit. My lord, pursuant to your lordship in a direction, my lord, we have filed this supplementary affidavit, lordship. From this supplementary affidavit, my lord, we have tried to, my lord, satisfy your lordship that, my lord, there is no want of bona fide, my lord, on the part of the state, my lord, to pray for this appeal, lordship. If I may, my lord, respectfully invite your lordships, my lord, to the relevant, my lord, part of this particular, my lord, supplementary affidavit.
We are reading it, Mr. Khalid. You allow us to read it.
My lord, we have narrated, my lord, facts from paragraphs 6 to 34. And, my lord, to show that there was no want of bona fide on our part, my lord, we have stated, my lord, started from paragraph 35 to 38, Lordship.
Wait.
Lordship.
What is paragraph 27, Mr. Galib? Page 10, paragraph 27. Ex parte order dated 29th November. What is this?
My lord, there was a second writ petition, my lord, which was filed, my lord, by the, my lord, respondents in this for implementation of the order passed by Justice Bagh.
All right.
So there also, my lord, there was a, my lord, laches on the part of the, my lord, State Council. They did not sometimes have, they did not appear in ex parte lordship.
Appeals to be এটা 4th January report 4th January 4th January কত না হ্যাঁ 27 দিন এসছে 4th January কিন্তু এখান থেকে আসছে এই আমাদের আমরা এই জানতে
Have you also filed an appeal against that 29 November order?
Recalling application because that
Right,
was an ex parte
You
order.
have filed recalling application.
Recalling, and they have preferred on contempt application also. The recalling was preferred after the contempt
The
application.
state's law department is in a mess.
Lordship, my lord, since lordship, I can't, my lord. pass
No, you
lordship.
can't. You can't. This is
Lord, so my lord, no fault on the part of the my lord.
their internal problem. That is the voice the appeal dismissed, right? Why?
One part, my lord, negligence is one part. If I, my lord, respectfully compartmentalize, my lord, this delay, my lord, one compartmentalization will, my lord, will be going to the learned advocate who had been conducting the case, my lord, because the department has been running after him for advice. I don't want to take his name.
Mr. Galig, apportioning the responsibility or the blame, the respondent is not concerned.
No, lordship, certainly. But my lord,
We have read your explanation. We have granted you opportunity. You have filed supplementary affidavit. You can't improve upon this.
lordship, certainly not.
You
lordship.
cannot improve upon this. Now we have read your entire supplementary affidavit.
So, my lord, from this particular, my lord, supplementary
Question
affidavit,
is whether this satisfies
want of
us,
bona fide.
whether this satisfies us or not. No. Not only, not necessarily want of bona fide is the only question. Callousness. Sheer callousness. From one department to other department. File ping pong.
Lordship, kindly appreciate. May I refer to some of the
To
pages?
decide whether a review application should be filed or not, it took a couple of years. Not filed. Review not
No, my
filed.
lord, no. The advice was whether you are to file appeal or review, my lord. That is the question which was asked to the learned advocate conducting the case.
Any further submission you want to make?
My lord, in addition to this, my lord, may I just respectfully submit, my lord, that there are certain judgments also, my lord, because I tried to, my lord, satisfy your lordships that there was no, my lord, that is point number one, want of bona fide on the part of the, my lord, state machinery. And secondly, my lord, since this is a question of impersonal machinery of the government, my lord, lordship, my lord, will, my lord, kindly, my lord, exercise the lordship
Some indulgence.
discretion.
Some indulgence, yes.
So in respect thereto, may I, my lord,
there is a limit to it.
lordship,
Some indulgence, yes, because it is impersonal machinery. We agree. The Supreme Court has said so in some
no, but
matters.
lordship, if I may satisfy your lordship, that there was no want of bona fide, my lord, because state was
How will
all,
you satisfy accepting the supplementary affidavit? You have said whatever you had to say.
my lord, from the documents, my lord, kindly appreciate. May I just refer to some of the, my lord, note sheets?
You better refer to the judgments.
Because, my lord, the department has been aggressively. Part one is, my lord, late lordship. Part one is that the learned advocate who had been conducting, he was, my lord, sometimes giving verbal opinion, not willing to give any written opinion.
You
My
should
lord,
not have, if that is the requirement and the learned advocate refused to give written opinion, you should not have such an advocate on your panel.
my lord, that, my lord, we don't have any, my lord,
That is
privilege.
your
The
problem.
state machinery, my lord, does not, my lord, state bureaucratic machinery does not have the discretion, my lord, to form this particular panel. Lordship knows it very well. Second part, lastly, the person who had been dealing with one legal advisor who was the OSD, for his non-performance, we had, my lord, not extended his service because of this particular latches which he had been dealing with in this particular file.
All right.
Taken a stand.
And lordship from,
Taken this land never belonged.
and one lordship will, my lord, be very astonished to see one document which till date had not been brought on record till date. Lordship, may I respectfully, my lord, invite your lordships to, my lord.
If it pertains to the merits of the case, please don't show us.
No, here from the document itself. my lord.
Pertains to the merits of the case, don't show us.
No, not variants.
এইটা নোটশিট এই নোটশিটেই বলেছিল এই কেস নম্বর পেজ 30 নোটশিটে এই নোটশিটের বেসিসেই বলেছিল রিভিউ করতে 11-17
No, that one they have some lordship.
যদি না
Nothing on merits we will
So, in
consider.
inquiry, lordship, one document I will show your lordship, one document, my lord, which is part of the record, which will show, my lord, the latches, my lord, which was on the part of the, my lord, conducting counsel.
Yes, you have to take the responsibility for that.
My lord,
If you engage such counsel, you have to take the
but,
responsibility.
my lord, at the end of the day, kindly appreciates, my lord. My lord, my lord, may I just place that document?
Gali,
once, lordship?
for the laches of an advocate, there can't be 5 years delay.
No, for, my lord,
The officers also, nobody took interest. Ping pong game continued. Why are we even arguing with you? We are supposed to hear you and pass our order. So kindly make your submission, allow us to pass our order.
no, lordship, may I, lordship,
Yes.
at the end of the day, my lord, state treasury will be at the receiving end and state will be at the receiving end, my lord.
State should have thought that before.
But my state will have to act through the council, lordship, kindly appreciate.
Yes. So better get better counsel who are serious with their work.
Lordship, may I, my lord, through my, my lord, a supplementary affidavit, lordship, I have tried to show, my lord, there was no want of bona fide, my lord, on the part of the state machinery. To, my lord, prefer this
What
appeal.
is state machinery? State machinery, the advocates and the officers. As you said, impersonal. State is impersonal.
So, lordship, in that event, my lord, kindly takes a view, lordship, a liberal view, my lord, since, my lord, the justice will be, my lord,
We told
will be, my
you
lord, a casualty.
there is a limit to being liberal. Yes, indulgence, some amount of indulgence we do grant to the state. In the first place, that is why we allowed you to file a supplementary affidavit. That is why we allowed you
She
to
may
file.
kindly put us on terms, my lord, in that event. But it let lord, your lordship may take a justice-oriented, my lord, approach so far as the section
You
5
better
is
go
concerned.
higher up.
Lordship, may I just cite, my lord, respectfully cite
Yes,
some of the
yes.
judgments, my lord.
Certainly,
Lordship.
certainly.
Hello. Lordship, the first judgment, my lord, that we'd like to cite before your lordship says, my lord. My lord, Limitation Act is a statute of repose.
One second. Mr. Vishwash, since Mr. Galib is relying on authorities, you consider whether you also want to rely on some authorities because we are going to record a judgment on this.
Yes, there are judgments also contrary to.
So to counter him, maybe not today, we'll grant you time. If you want time, come back Monday. But you also consider whether you want to cite judgments.
It requires. Now, my lord, your lordship's judgment just few days back on the same point. And
No, he'll be
Yes,
citing
yes.
all Supreme Court judgments.
I know this. And there are also contrary judgments that this latitude cannot be, for that reason, my lord, petitioner will not suffer.
On this point, no, we'll hear you. What
Yes.
Mr. Galib is arguing is that it's an impersonal machinery. So a very liberal view has to be taken on that. Yes, Mr. Galib.
Yes.
My lord, the first judgment, my lord, that I may respectfully, my lord, cite, my lord, before
Yes.
lordship is 2006, my lord, 5 SCC. Lordship, may I hand over lordship? Lordship's 2006, volume 5 SCC, page 353, my lord. Proposition is, my lord, the Limitation Act, my lord, is a statute of repose. It, my lord, bars the remedy, my lord, but, my lord, does not extinguish, my lord, the right.
Absolutely. Correct.
My lord, we are before lordships, my lord, today with clause 15, my lord, appeal. My lord, is the first appeal, my lord, which, my lord, is a substantive right. So, my lord, paragraph 11, my lord, may I refer to lordship. Para 11, my lord, limitation is a statute of repose. It ordinarily bars the remedy, but does not extinguish a right. Placitum F, lordship. So, my lord, since we are before lordships, my lord, with a, my lord, let us patent appeal. That too, my lord, in a case, my lord, wherein the writ petition, my lord, the writ petitioners, my lord, have prayed for mandamus without, my lord, even able to show as to what fundamental right, far less than a legal right, has been infringed. Because the lands, my lord, were not at all acquired, but they were praying for compensation. And a document, my lord, which was, my lord, prepared in their presence upon field inquiry.
It was an ex parte order. Let a single judge's order, ex parte order.
The impugned judgment with your lordship is not ex parte lordship. But, my lord, there was a direction that you hold an inquiry, and, my lord, the state council will file a further report.
The state could not point out that this land was not
That
acquired.
report was never placed. Even till date also, that was never placed. And they are never challenged also.
Next judgment.
In the second writ petition also, they have not challenged that, my lord, field inquiry report where they were signatories. And the inquiry report finding is that all your plots are not subject matter of this particular LA case.
Very well. Next judgment.
My lord, next judgment, my lord, 2005, my lord, volume 3, SCC 752.
Para.
My lord, paras, my lord, 2, my lord, it was a, my lord, a proceeding, my lord, by the state. Kindly sees para 2 speaks of the fact the state of Nagaland questions correctness of the judgment rendered by the learned single judge of the Guwahati High Court, Kohima, refusing to condone the delay by rejecting the application filed under Section 5 of the Limitation Act and consequently rejecting the application for grant of leave to appeal. Before we deal with the legality of the order, refusing to condone the delay in making the application for grant of leave, a brief reference to the factual ground would suffice. My lord, thereafter, my lord, the Honorable Supreme Court went on to, my lord, narrate the facts, my lord. And kindly sees, my lord, para 3 also. In support of the application for condonation of delay, it was submitted that the aspects highlighted clearly indicated that the authorities were acting bona fide and various decisions of this court were pressed into service to seek condonation of delay. The High Court, however, refused to condone the delay of 57 days on the ground that it is the duty of the litigant to file an appeal before the expiry of the limitation period, merely because the Additional Advocate General did not file an appeal in spite of the instructions issued to him that did not constitute sufficient cause. And further, the fact that the records were purportedly missing was not a valid ground. It was noted that merely asking the Additional Advocate General to file an appeal was not sufficient, and the department should have perused the matter and should have made inquiries as to whether the appeal had in fact been filed or not. Accordingly, the application for condonation of delay in filing the appeal was rejected, and consequently, the application for grant of leave was rejected. Now, my lord, kindly sees, my lord, what the Honorable Supreme Court says in paragraph 8. May I respectfully invite your lordship to paragraph 8 onwards. The proof by sufficient cause is a condition precedent for exercise of extraordinary discretion vested in the court. What counts is not the length of the delay, but the sufficiency of the cause, and shortness of the delay is one of the circumstances to be taken into account in using the discretion. In so and so case, it was held by this court that Section 5 is to be construed liberally so as to do substantial justice to the parties. The provision contemplates the court has to go in the position of the person concerned and to find out if the delay can be said to have resulted from the cause which he had adduced, and whether the cause can be recorded in the peculiar circumstance of the case as sufficient. Although no special indulgence can be shown to the government, which in similar circumstances is not shown to an individual suitor, one cannot but take a practical view of the working of the government without being unduly indulgent to the slow motion of its wheels. Milord, paragraph 9, Lordship, may I respectfully read out. What constitutes sufficient cause cannot be laid down by hard and fast rules. In so and so case, this court held that discretion given by Section 5 should not be defined or crystallized so as to convert a discretionary matter into a rigid rule of law. The expression sufficient cause should receive a liberal construction. In so and so case, it was observed that the true guide for a court to exercise the discretion under Section 5 is whether the appellant acted with reasonable diligence in prosecuting the appeal. In so and so case, a bench of 3 judges had held that unless want of bona fides of the such inaction or negligence as would deprive a party of the protection of Section 5 is proved, the application must not be thrown out or any delay cannot be refused to be condoned. Para 10, Lordship. In so and so case, which is a case of negligence of the counsel, which misled a litigant into delayed pursuit of his remedy, the default in delay was condoned. In so and so case, this court had held that there is no general proposition that mistake of counsel by itself is always sufficient cause for condonation of delay. It is always a question whether the mistake was bona fide or was merely a device to cover an ulterior purpose. In that case, it was held that the mistake committed by the counsel was bona fide and it was not tainted by any malafide motive. Para 11, Lordship. In so and so case, it was held that whether or not there is sufficient cause for condonation of delay is a question of fact, dependent upon the facts and circumstances of the particular case. In so and so case, it was held that the appellant had sufficient cause for not filing the appeal within the period limitation. This court under Article 136 can reassess the ground and in appropriate case, set aside the order made by the High Court.
Yes,
or the
12 is actually what you want to write. 12
yes, I want to refer to 8 to 15 and 17.
We have gone through it. It helps you, no doubt helps you.
8 to 15, Milord, and 17.
Yes, you will have to deal with these cases, Mr. Vishar. Because these cases do seem to say that a pedantic approach is not to be taken, where refusal to condone will cause substantial miscarriage of justice. That is a ground for condonation of delay. These things are observed. So we have to consider these.
Lordship, next judgment, Milord, 2002, Milord, Volume 3, Milord, SCC, Lordship, 195, Lordship. Milord, here up to 5 years, Milord, 2002, Volume 3, SCC, 195. Milord, in a letters patent appeal, Milord, delay of 5 years, Milord, was condoned, Milord, by the Honorable Apex Court of the country, Lordship. Milord, may I respectfully invite your Lordship, Milord, first.
The period, the length of delay is not
Lordship,
important.
that is what, Milord.
It's not important.
So, Milord,
it may be 8 years delay also. So long as there is, if sufficient explanation is there, any amount of delay can be condoned.
So that is what, Milord, I am trying to satisfy Lordship from the judgments and factual aspect also.
That is the principle of law. That if sufficient explanation is furnished, any amount of delay can be condoned. Question is, in the facts of the case, the explanation that you have furnished, whether it is sufficient or not, and that the court will decide.
Vis-a-vis the state machinery.
Keeping in mind, it is
Lordship.
a state machinery.
Milord, this judgment, Milord, may I place, Lordship?
Yes.
Milord, Para 2, Milord. Order impugned in this appeal has been passed by a division bench of the Jharkhand High Court in latest patent appeal, upholding order passed by the learned single judge, whereby regular first appeal filed by the defendants against decree passed in a partition suit involving approximately 116 acres of land so and so, plaintiff has been disposed of, holding the entire appeal has become incompetent as during the pendency of the appeal, appellant so and so, the appellant expired, and as no steps of substitution of their heirs and legal representatives were taken into within the time prescribed. The same abated, and the application for substitution of their heirs after setting aside abatement and condonation bill was rejected after recording a finding that no sufficient cause was shown either for condonation of delay or setting aside abatement. Now, Milord, may I respectfully, Milord, invite your Lordships, Milord, to Milord, paragraph 13, Milord, placitum B and C. Paragraph 13, Milord. Sorry, Lordship. Page 198, Milord. Page 198, Milord. Of the judgment of the report, Milord.
Yes.
Placitum B and C part, Lordship. May I, Milord? The sentence starts with, however,
Yes.
in relation to appellant 22, the delay was of about 5 years. And in relation to appellant 41, delay was about 3 years, both of whom were transferees and belonged to village different than the village and police station in which members of joint family are plaintiffs and contesting. The appellants before the High Court were rustic and illiterate villagers, and undisputedly no sooner their lawyers advised, steps were taken with utmost expedition without any loss of time, Lordship. And Milord, paragraph Milord 13. Para 13 of the report, Lordship. In view of the foregoing discussions, we are clearly of the opinion that on the facts of the present case, the division bench of the High Court was not justified in upholding the order passed by learned single judge, whereby prayers for condonation delay and setting aside abatement were refused, and according to delay.
This really doesn't help you much.
It was in LPA, Lordship.
Doesn't matter. Accepting that 5 years delay was condoned, it doesn't.
Lordship. Milord, here, Milord, next judgment, Milord. Only 3 more judgments I do have, Milord, in my kitty. Milord, I shall try to, Milord, satisfy Lordship, Milord. AIR 1991, Milord, Supreme Court, page 90, Lordship. Here, Milord, 19 years delay, Milord. The matter relates to land acquisition case, although the state delay was not on the part of the state, Lordships. May I, Milord, respectfully invite your Lordships, Milord, to paragraph, Milord, 2.
Paragraph?
2, 3, and 4, Lordships. Kindly seize, Milord, paragraph 4 at one point, Milord, Honorable Supreme Court says, paragraph 4, Lordship. Second page, Lordship, kindly seize. The appellant furnished some explanation about the delay. Lordship, got that sentence, Lordship? In laying his claim and approaching the court, if the matter is strictly screened, possibly the explanation for condoning this long period of inaction may be difficult to be overlooked. Nonetheless, Milord, the condonation, Milord, was condoned, Lordship.
There's no principle of law laid down in this matter. 142 is always there. Please don't forget that. It doesn't not.
Milord, this was a judgment not under 142. Had it been so, Milord, I would not have pressed, Lordship.
142 is not always referred to. But what is the principle of law? Tell us.
Milord, principle is, Milord, since
in this case there is no principle of law, you accepting that.
No, since Milord, here if a Lordship, Milord, kindly refer to the sentence I had, Milord, read, Milord. If the matter strictly screen, Lordship, may I?
2005 3 SCC is a good case.
But there are no, Lordship. Here, Milord, the Honorable Supreme Court came across certain instances where the state authority had given the allotment.
Yes. Next.
So that was the basis for allowing his, Milord, delay of 19 years.
Yes.
That also, you also give him the allotment. Milord, 2023 10 SCC, Milord. 2023 10 SCC, Milord, page 531. Milord, here, Milord, this judgment of the Honorable Supreme Court has taken, Milord, care of so many things. One is prejudice factor of the other side. Secondly, Milord, the delay by the government, that is impersonal machinery. And after analyzing all the, Milord, earlier judgments, Milord, it has come to the conclusion. Kindly seize, Milord. May I, Milord, respectfully refer to, Milord? Paras 1 is the challenge. Para 2, Milord, it was no doubt 479 days. Para 2 is the issue. Para 2 is the issue. Milord, page, Milord, 537 of the report, Milord. Placitum A, Milord, where, Milord? It starts with the, Milord, nomenclature, the precedents. And Milord, Lordships, Milord, will come across, Milord, all the, Milord, judgments that have been dealt with. Starting from paragraph 17, 18, the Nagaland judgment, which I, Milord, have referred to, Milord. 19, 20, 21. 22, my lord, here, my lord. Paragraph 22, placitum G part kindly sees it has taken care of a judgment of 2,449 days delays also, lordship. And my lord, kindly sees, my lord, paragraph 22, if I may read out, lordship. Para 22, placitum G part. It then proceeded to set aside the impugned judgment condoning a delay of 2,400 days in challenging the sentiment based on lack of bona fide. So, my lord, lack of bona fide and want of bona fide, my lord, is the sheet anchor, my lord, seminal issue, my lord, on which, my lord, I may respectfully submit. Your lordship will kindly deliver the order on this particular matter. So, it went on to consider these judgments, my lord, 23, 24, 25, 26.
Yes, yes.
Up to 28, my lord, it dealt with the different judgments. Next, come, my lord, the analysis part, lordship. Page 541 of the report. And, my lord, may I read out? Now, my lord, may I read out me these few paragraphs, my lord, starting from 30. Considering the aforesaid decision, there cannot be any quarrel that this court has stepped in to ensure that substantive rights of private parties and the state are not defeated at the threshold simply due to technical considerations or delay. However, these decisions notwithstanding, we reiterate that condonation of delay being a discretionary power available to courts, exercise of discretion must necessarily depend upon the sufficiency of the cause shown and the degree of acceptability of the explanation, the length of delay being immaterial. Para 31, lordship, sometimes due to want of sufficient cause being shown or an...
Yes, Mr. Garib, we've gone through it. Need not place. This helps you.
32, my lord, 34. And, my lord, 35 is important, my lord, the concluding part.
Yes.
35. 35, lordship. And, my lord, para 39, my lord, has taken the prejudice factor of the other side. Para 39, lordship. It has taken the prejudice part of the factor of the other side. And has answered, my lord, in paragraph 40 also. How, my lord, shall be dealt with? And finally, my lord, paragraph 41, lordship. Having bestowed serious consideration to the rival contentions, we feel that the High Court's decision to condone the delay on account of the first respondent's inability to present the appeal within time for the reasons assigned therein does not suffer from any error warranting interference. As the aforementioned judgments have shown, such an exercise of discretion does at times call for a liberal and justice-oriented approach by the courts, where certain leeway could be provided to the state. The hidden forces that are at work in preventing an appeal by the state being presented within the prescribed period limitation so as not to allow a higher court to pronounce upon the legality and validity of lordship.
Yes.
Lordship, my lord, this, my lord, I would like to merely rely upon lordship. And lastly, my lord, if I, my lord, may satisfy lordship with a coordinate bench judgment of our Hon'ble, my lord, High Court lordship. My lord, here, my lord, Hon'ble coordinate bench, my lord, says in paragraph 2, my lord, এটা হচ্ছে MAT 1594 of 2023. Para 2, my lord, Hon'ble coordinate bench of our court says there is an application for condonation of delay of 530 days in filing the appeal. We have perused the affidavit filed in support of the petition, and we find that the explanation given is not satisfactory. But, however, we do not wish to foreclose the avenues open under the law to the appellant. So, my lord, this is the last, my lord, resort, my lord. I have, my lord, opened from my cache of, my lord, artillery. So there might be a crash landing. I do not
want to argue today. You want to argue today or you want time?
So far as judgment part is concerned, my lord, I shall take time, or in time I shall.
No question as far as judgment. If you take time, take time. We'll tell you very frankly. These judgments have made some impression on us. Justice-oriented approach.
Lordship,
liberal approach.
The present case is different.
Only one mercy, my lord. Para 38 of our supplementary affidavit, that COVID period, my lord, which my lord Hon'ble Supreme
Your
Court was pleased
supplementary
to
affidavit,
condone,
the
my lord.
entirety we'll go through, no problem.
That COVID period lordship kindly take into consideration.
Fact of the case is totally different from the back has been mentioned in the. No. Let me. But kindly see the list of dates.
No piecemeal, Mr. Vishwas. Either you complete your argument today or take time and come back.
No, if my learned friend is willing to touch upon the fact, then he should come up in affidavit.
List of days regarding delay.
Give us,
Subsequent cause of action arose.
give us, we shall deal with. Kindly give us a copy, we shall deal with it in reply, lordships.
Mr. Galib, learned advocate appearing for the appellants, concludes his opening submission in connection with the application for condonation of delay. Stop. Paragraph, Mr. Vishwas, learned advocate for the respondent oblique writ petitioner, respondents oblique writ petitioners, seeks time to come back better prepared. Tell us when. Paragraph lists the matter once again on 13, March 13.
If my learned friend is willing to delay upon this list of day, may I be given a copy of this lordship?
If he wants to hand it up, he has to give you a copy.
Lordship. I've received. Grateful.
Grateful.
Item number 6, I am appealing for the appellant. This is my leave to appeal, my lord. Last occasion, this matter was heard by your lordships, my lord. In respect to the acquisition matter, my lord, wherein, my lord, I was not made a party, in spite of the fact that, my lord, I have a interest in respect to the land.
You are for?
But I am for I am for the appellant. The respondent in writ petition in item number 7. Both are from the same order.
Oh.
6 is by a non-party, leave to appeal. 7 is by HIDCO, the appeal from that order. But if your lordship kindly recollects, Mr. Abrutosh Mujumdar had started, but because my learned friend's matter was dismissed possibly, and then possibly as mentioned. So, but he was there. There's a matter fixed at 12:30, so he has gone. He has only requested me, indicated me to request only one thing, that they were supposed to rely on an original application filed before the Land Reforms Tenancy Tribunal. So that copy, we have not. They told that they would give that copy. That is not.
I have the certified copy with me. If your lordship directs me, I can.
And there's one other thing, if they leave to appeal could be heard first, because that would possibly be required for the main appeal to be heard. Because then that would be, this is what he has told me. But,
but we are considering your appeal.
Yes, but
Nothing to do with my learned friend's appeal.
So,
so why should the decision in your appeal be dependent on what?
No, because from their appeal, they have disclosed certain documents, and which we will also check from looking at the original application, which they said that they would be relying upon.
They have no appeal. There is no appeal today.
So we'll have to stand or fall by our appeal.
Yes.
Very well.
You started. So you take that copy of whatever application.
Yes. And could we come back any day next week then?
Tell us, give us the date.
But any day next week.
No, I'm opposing. Start today.
Accommodation is paid for.
Can you remember this when Mr. Gupta Miller opposes my prayer for an adjournment?
He dare not oppose. He never does.
Right from
How many heads he has on his shoulders?
and what I faced outside the courtroom that day.
I gave it back. I didn't give it to the side that way.
Insofar as physical volume is concerned, he is no match.
In every way, I am no match.
The problem is that he is now getting into a vehicle which is huge. And the best part is he doesn't use his own money.
He's saying this to whom?
He doesn't use his own money. He uses something else.
He's saying.
So I'm handing over here.
আমাকে দে
তেরি তো সব
তোমারই তো কাজ
টিকিট করতে সাথে Accommodation is paid for on behalf of the appellants.
অর্থ দেখানো
I've interpreted the appeal on by the Arijit court. Why, my lord? The claim of lease is 0.77 decimal of land. Trial court or the order of civil judge was declared yes, you are entitled to 0.77 decimal of land. So today, what is the ground for preferring the appeal? Because he is not the prejudiced person, this can be termed to be a person aggrieved.
My lord,
Very well.
That portion, my lord, is over that.
my lord, CA, I'll clarify, my lord, the original land was 5.6 acres.
No, maintainability of which appeal?
By the Hitco.
I'm
Hitco.
saying both appeals are not maintained.
That is subject to correction. That will be argued.
No, no, ours can only be on merits. Can't be that it can't be maintained.
Paragraph as requested, comma.
Merit hobe.
Let this matter be listed again on. Tell us, Mr. Gupta.
Yes.
Don't say any day. Any day is not a date.
But Wednesday, my lord.
Wednesday.
Next Wednesday.
বুধবারে ডেট দিয়ে দাও আর 6 নম্বরটা কি জাস্ট অ্যাজিয়ন করে রেখে দাও
Can you direct them to serve us a copy of what they want to rely upon?
he will give you
Well, this is the original application
Acha,
which
ye,
has been filed before the
Another application.
learned tribunal. So that is their application, my lord.
কি দিবি কি আমি কি করে জানবো?
It's certified copy.
যা দিয়েছিস বিষয়টা আমাদের যে অন্য কিছু অ্যাড করে দিবি আমি কি করে জানবো? Knowingly. BMW 6 সিরিজটা কিনেছে সেটা জজকে বল।
এখন জানি না ভাই অডি BMW সব চোরাচুরি।
Porsche. আমি তো কি Porsche Cayenne।
আমার তো
পিঙ্কি টপ। আমি শুধু ভাবি বাকিরা কাঁচের ঘরে থেকে আমার একটা
very well Wednesday
কোনো ব্যাপার না। নিট খান ইট সব করতে পারি। আমার কোনো প্রবলেম নেই।
number 8 मतलब English matter मतलब so much ready with the appeal expense.
But it's matter I'm happy for the
This matter, I beg to appear on behalf of the writ petition or appearance before your lordship.
municipality one. One of the respondent.
Your lordship will find from the order sheet, your lordship kindly have a look.
it is not here pass over
Matter number 9. My lord, this matter, my lord, I am appealing for the private respondents. If your lordship may kindly.
I am for Jila Parishad.
Lord, I am appearing on behalf of the, my lord, my appellant writ petition.
Your lordship can take some Monday subject to continuation. আজকে দিতে ছেড়ে দাও প্লিজ করে দিচ্ছি আজকে ওইটা হবে বলে
on the prayer made on behalf of
private respondent
the private respondents comma let this matter stand adjourned
so much
and we listed again on Monday date
আমি আগে দিন ছিলাম
I am now my lord, item number 10, I am for the petitioner, my lord. I am praying for a short passover, my lord.
I am for কি হলো
11 lord, I am for the petition.
আজকে
My lord, item number 12, I am for the appellant, my lord.
all parties present
My lord, corporation. That's it.
what did I ask whether corporation is present or not
My lord. All parties.
all parties what is the answer
My lord, the private respondents are not there.
11 lord, I am for the 11 lord.
Both side was there, but what my last friend has not responded.
Couldn't understand lordship.
which one
Because 10, 11. Item number 10 I am appearing lordship there.
even all parties were there
11 aছেন তো হ্যাঁ blood hitco is the blood party necessary party hitco my learned friend is
And the
appearing
state government is the direction was on the last occasion lordship.
তাহলে state তো নেই তাহলে ছেড়ে দিচ্ছি
in 11 are all parties there simple question nobody can answer
State তো ছিল।
তাহলে বলছো কেন no my lord, all parties are not
sure
But my appeal, but I have Rajesh. Well, at the Vidhannagar Municipal Corporation is there, but my lord, I do not know whether the private respondents are there. They did not appear in the writ petition. Very well. my lord.
you are for the private respondents all of them
one of them
Well, that is why there is an issue with one of the parties, one of the appearing parties.
chalo.
If your lordship kindly keeps this matter this coming Tuesday, then I'll complete the service. I'll serve them again. My lord, if that is
learned advocate for the appellants says that he does not have specific instruction as to whether service is complete.
Well, that service is complete, but I'll serve them again. The one private respondent, there is an issue with his appearance. Well, even before the writ court, I'll serve them again. I'll come back on Tuesday. That is why. That is why I say, well, I have the affidavit of service.
On the prayer for adjournment made on behalf of the appellants, let this matter stand adjourned and be listed again on Tuesday. But on that day, fresh affidavit of service shall be filed in court.
My lord. My lord, may I only request this? My lord, it may retain its position under the same heading.
Heading, why do you think heading will change suddenly?
No, Lord. Grateful.
14 lossy, I am appealing with the appellant loss. Private respondent and appellant loss.
Yes, 59.
On behalf of Kolkata Municipal Corporation. This is my appeal. I'm led by Arijit Dotto.
My lord, I am appearing virtually, my lord. My lord, I am appearing for the appellant.
Yes. No, this is my appeal. There's private. Yes. There are private. Lordship allowed my application, can 1, regarding the Section 5 application.
Allowed on the last occasion.
Yes.
The Section 5
And there are
application
other
was allowed.
two application. If you would, Lordship, hear my senior.
My lord, may I pray for this? The private.
Time for the state respondents, my lord. Yesterday the matter was taken up, my lord, and your lordship has asked this advocate from the state to appear.
But I am for the respondent number 11, my lord, in this matter. I was the writ petitioner in the court below.
Well, the appellant is perhaps not here, my lord. I am for the corporation.
I am from the Jilla Parishad, my lord.
Item number 18, I am led by Mr. Devasis Banerjee. We have the appellant matter short pass over. Please go to number 1, my lord.
But in item 19, my lord, I have sought for extension of time to file affidavit in opposition with a medical certificate of my client. This is a very short matter.
You appear for whom?
Appellant. Appellant.
Appellant will file affidavit in opposition.
Because challenging the order passed by the learned single judge, my lord had been pleased to pass an order to exchange affidavit within certain period. Since my client was ill, the affidavit in opposition could not be affirmed within time. I have made an application for extension of time for
not followed. Ki dekhi ki bolchen?
So lordship kindly turns to page 16, so to the bottom. That is the ordering portion. The sentence starts with accordingly without.
Oh, remand. It's a remand.
Yes, ma'am. Wherein my lord had been pleased to pass an order directing the parties to exchange affidavits within certain period. Or since I have annexed the copy of the medical certificate, my lord, I have affirmed on 6th instead of 29th, my lord.
Hey, have you served this application?
Yes, my lord. I have served.
Affidavit of service?
Yes.
Madam, I am for the respondent number 1.
You are the respondent you are one of the respondents in the writ petition. Only respondent now, one of the respondents.
Only respondent.
I am the, actually, my lord, I am the petitioner of the writ petition. In favor of me, order was
the
passed.
writ petition, you are the only respondent.
Only respondent.
Only private respondent, my lord.
Or the my learned friend take out and writ petition.
The present applicant had come up in appeal against against a judgment and order dated December 11, 2023, whereby the writ petition of the respondent number 1 herein, being WPA number 16654 of 2023, was disposed of by a learned judge of this court. Paragraph. By a judgment and order dated January 15, 2024, a coordinate bench set aside the order under appeal and remanded the matter
কি করছে এখনো বুঝতে পারিনি
to the learned single judge, having determination to hear the writ petition, after exchange of affidavits. Stop. Affidavit in opposition. Liberty was granted. Liberty was granted to the respondents in the writ petition to file affidavit in opposition by January 29, 2024. Paragraph. The present application has been taken out by the appellant, who is the private respondent in the writ petition, for extension of time to file affidavit in opposition before the learned single judge. Stop. Documents have been annexed to the application showing that for medical reasons, the applicant could not affirm the affidavit in opposition within the time period granted by the division bench. Paragraph. Having heard learned counsel for the parties, we extend the time period. When did you affirm?
No, I have affirmed on 6th. On
February.
the same day, I have taken out
6
this.
February.
Yes, ma'am.
February. We extend the time period for the applicant to file affidavit in opposition before the learned single judge by February 8. They have already affirmed on 6th February. We are extending the time period till 8th February. Take the affidavit, file your reply, have the matter heard out. Stop. Paragraph. Learned advocate for the applicant says that the learned advocates for the writ petition time. Stop. Now that we have extended the time period for filing affidavit in opposition, let a copy of the affidavit in opposition be made available to learned advocate on record for the writ petitioner in course of the day. Stop. Her reply before the learned single judge
within 7 days.
Within a week from date. Tarikta diye dao. Tarikta diye dao. Paragraph. The parties will be at liberty to mention the matter before the learned single judge. After
That is running in the list.
It is running in the list. It is due to
then we say nothing. Yes, we say nothing. Application is disposed of.
March of.
Affidavit of service today now.
Deal.
Lordship, for the appellant, my lord, I'm praying for only not today, my lord, because Mr. Nilabho Vera was appearing in this matter yesterday. Nilabho Vera, my lord, his grandfather died, my lord, last
Put
Friday.
you on the prayer mirror on behalf of the appellant. The matter stands urgent for the day. Next.
Oblige, your lordship.
Item number 20 million. Can it be taken up on Monday? Tomorrow, Millard.
Let the matter stand urgent and be listed again on Monday date.
Oblige.
My lord, praying for a Passover, my
Lordship, in item number 20.
You are ready in the matter?
my lord, it will be good if Mr. Banerjee is submitted.
Passover.
Lordship, in item number 21, may I pray an accommodation for the stay, Lordship? The learned advocate on record for the opposite party Due to some personal difficulty, he could not come to court today. May I please?
Which opposite party?
Opposite party number 1, Lordship.
What is the name of that party?
Ramnarayan Rai.
Very well. On the prayer made on behalf of the respondent number 1 in the appeal, comma, let this matter stand adjourned for the day.
Keep your questions.
My lord, praying for a Passover, my lord.
Which is the matter which I told you to be ready?
My lord, in item number 21 to 20. My lord, I'm ready with the matter.
26.
But I am for the appellant. Lordship. In item number 26, Mr. On Banerjee is appearing on behalf of Bali Municipality, Lordship. On his ground, I am praying for not today.
Well, then make it not this way, man.
On the prayer made on behalf of the parties, comma, let this matter stand adjourned for the week and be listed again on Monday. Date the other.
Great, please.
28. 29. 30. 31.
31 and 32, my lord, I'm being led by, I appear for the respondents, my lord. I'm being led by Mr. Rajoshi Dotto. He's unwell, my lord. We kindly keep it next week. 31 and 32.
The appellant is not here. Why are you so anxious?
32. 33. 34. 35. 36. 37. 38. 39. 40. 41. 42. 43. 44. 45. Therefore, application item number 3.
Your Lordship. Your Lordship. Your Lordship, I appear on behalf of the appellants. I'm led by Mr. Dutt in this matter.
Mr.
Dutt, Shuman Dutt in this matter. Lordship, he's in some difficulty possibly taking this matter up this week. Possibly praying, Your Lordship, for the next week. Matter can be taken up.
On the prayer made on behalf of the appellants,
appellants,
comma, let this matter stand adjourned for the week and be listed again on Monday.
Lordship, if it be possible on Tuesday.
Tuesday. Letter the other.
Greatly.
নামটা নিয়ে নাও হ্যাঁ দিচ্ছে না বলে তুমি চেয়েছো Yes, Mr. Bose.
Mr. Dotto, S. Dotto, junior member of Bar Library, Mr. Shumon Dotto's son.
I know. I just can't remember the names. That is the problem.
A big name. S. Dotto, for short. My lord, now, my lord, this matter was released by Justice.
Affidavit of service?
Yes, my lord, more than that, 2 orders have been passed. My lord, it was released by the bench presided over by Justice Basak on the ground that Justice Basak had appeared in a connected matter when he has a counsel. My lord, it's a... My lord, your lordship may find an order dated 18/12/2023.
Yes.
And there, my lord, proves the appearance of counsels which I have served. They all appeared. My lord, if you still wants the affidavit service, we have got it, my lord.
File it. If you have got it, file it.
Yes.
But they had appeared. They had
yes,
appeared.
they had appeared. My lord, I don't know whether it's
Only thing, Mr. Bose, if you look at the order dated 18 December,
yes,
whereby the matter was released,
yes,
it records the attendance of learned advocates for respondent numbers 1 to 8.
Yes.
And respondent number 21.
Yes.
What about the other respondents?
My lord, 1 to 8 and 21, the rest are, my lord, I
to 20, 9 to 20.
My lord, I am. Yeah. 21 is one of the private. My lord, they are all part of the, my lord, some of them. Oh, the other one, my lord, is state of West Bengal. Well, my lord, in my matter, কোথায় দেখি order-টা?
No, but there aren't so many respondents. There's some mistake there.
No, my lord, 1 to 8. 1 to 8.
Mr. Bose, in the appeal, there are only 12 respondents.
In the appeal, which one am I?
There are only 12 respondents.
My lord, I'm sorry. কোথায় আমার briefটা? এটা কি আমার? My lord, I don't find there are more than 12.
Who all added by hand.
Yes. It was added. There's a leave granted.
Have they been served, the added respondents?
Yes, my lord. There's affidavit of service. They were added by hand, my lord, later on. Hey, এখানে, my lord, my junior was there. My lord, can it be clarified?
Which point, my lord?
এখানে কি let us have all the respondents be served? They were some added, I think. There's an order for it.
Respondent 9 to 21.
Service on respondent 9 to 21. এর আগের অর্ডারটা কোথায় আছে? এর আগেরটা you got an order for service on them. Affidavit service to দেখি। যেটা ফাইল করছিলে? Yes. Well, pursuant to the order on 12th December, I did serve copy of memorandum upon advocate for the 1 to 8 and also on 9 to 23 by speed post. That's the affidavit.
Yes, it's by speed post. Where is the, have you seen delivery track report?
I can see.
All received.
Well, that's what.
Kindly satisfy yourself, Mr. Bose.
Well,
Some are delivered, some are refused, your lordship.
Some are refused.
all private, my lord, respond.
Where will you proceed?
Yes. You hear it, what the matter is about, then my lord, I decide. My lord, there is a colliery called the Searsole Colliery. It's pure Searsole Colliery. My lord, after the Nationalization Act, all collieries, as per the Nationalization Act, vest with the my lord, vest these private owners. It's vest with the government, the coal company. Now, my lord, in this case, it appears.
Which is the parent company, Coal India?
Coal India, my lord, it vests on the coal companies. Now, my lord, this was the case, but whatever it is, it's neither here nor there, because, my lord, it appears that two dark numbers or part of it, which is the subject matter of this writ petition, my lord, there was a requisition notice issued. My lord, there was a requisition notice issued in 1975. My lord, if it's I'm the owner of the property, no need for requisition notice. But whatever it is, proceedings proceeded on the basis, ignorant of the fact of the Nationalization Act, to have a requisition. We wanted that land.
Act was of the year?
My lord, the requisition notice
Act
was, my lord, of 1973, but the requisition notice of 1975. Now, my lord, requisition, this is under not the acquisition under the 1894 Act. It is requisition under, my lord, the 1948 West Bengal Requisition
Act 2.
The difference is, my lord, the property is requisitioned and then acquired, my lord, by the state of
1A. Not necessarily, it may be acquired.
May be acquired. Now, my lord, so, my lord, when for the purpose of the 1948 Act, requisition notice was given, and, my lord, the Section 4 notice was also issued. and paper possession of the land, paper possession of that portion of the land was given to us, which we accepted, my lord. There is a paper possession. But the fact remains, and this is clarified by several orders gone to the Supreme Court, my lord, the actual possession was never taken. There was no mining ever done. The reason being, my lord, your lordship is aware that when you want to acquire, this is not under our new act, that first pay the money and then acquire. Previous thing was that you requisition and God knows when you will get paid and delay and hold over the land. This was the old act, which is done away with for good. My lord, so what happened in this case, the entire proceedings, there is a notice, my lord, of 1988 saying section 4 notice. So, my lord, 1976 and nothing happened. My lord, up to 1988, there was this notice for acquisition. Then, my lord, there were demands, I believe in 2004-1 and 2000, that this is the possible cost of acquisition, please pay the money. My lord, the first demand was in 1994 and the second demand was in 2008 or 10.
Demand by?
Demand by the government that this is the possible cost of acquisition, pay the money. Now, my lord, we paid the money, the entire money to the state of West Bengal. By that time, my lord, the 1948 Act was done away because the period, my lord, it just lapsed. It's just lapsed. And I'm again telling your lordship, land was never worked. There was never mined. It was just left there. So, my lord, the private owners, naturally, they come and file a writ petition before then Justice Shomitra in 2011, saying that where is it is lapsed, give it no, the private owners may not having acquired the land in 1985, when all this, in 1985, when the acquisition was there. Whatever it is, I am not concerned about that. The fact remains, I have paid good money as demanded by the state to the state of West Bengal. Now, my lord, and this is very important, my lord, in 2011, my lord, learned single judge, Justice Shomitra dismisses the writ petition of the side that you are coming after such a long time. What compensation, and you are coming, you have purchased it during pendency of the so-called acquisition, dismissed. Now, my lord, matter goes to the division bench, and this is most important. In the division bench, my lord, all this debate and argument of the state of West Bengal, my lord, starts, and amicus curiae, Mr. Shaktinath Mukherjee is also appointed to say, no, acquisition has not come to an end. Because why? Because there is a validating act. My lord, the West Bengal, there is a 2000, that by virtue of which 2015, it will continue this. So you can carry on with this exercise, my lord. This is the order. According to me, the validating act does not apply, my lord, according to me now, my lord, because my clients, my lord, in the opposition, which was filed before the learn, it's been recorded in the judgment, that never took this point. They said that we have paid, we have done all this, took this point. But, my lord, before the learned division bench, point was argued, it's noted, no, we have become owners by virtue of adverse possession. This is contrary to the stand taken in the opposition, whatever the council, my lord, and I'm bound by it, my lord. And the order is passed, my lord. Yes, it is lapsed. And return the land. That's the order of the division bench. Whether it's right, you return the land. And the order is of 2012. You return the land and pay, and pay the company. There's the word is the acquiring authority to pay the compensation. Acquiring authority to pay the compensation. My lord, ignoring the fact the compensation had already been paid.
Acquiring authority is the state.
My lord, acquiring authority to pay the compensation. My lord, if you interpret it to be that at my purpose, it is, my lord, I had already paid.
You are the requiring authority.
I am the requiring authority. Now, my lord, because under the act, the property vests in the state at the end of the day. My lord, that's what, if you want to acquire it for public purpose, at the instance of someone, property vests in the state. and he had to pay, and all money had been paid. Now, my lord, 4 appeals, special leave petition are preferred from that order. 4 special leave petition. My lord, one by district magistrate, because money is lying with them. All you have to do is...
How much money roughly?
My lord, it is compensation is very little. My lord, I think it is 8 lakhs, 9 lakhs. 9 lakhs, roughly 9 lakhs, 8 lakhs, 9 lakhs, 5 is 2 installments paid, good money. My lord, maybe when the so-called lapse happened, but money paid to the state of West Bengal. So it's in the pocket of the state of West Bengal. My lord, and someone is asking for, give me the money for compensation. Now, my lord, state 3 appeals are preferred, especially petitions. Yeah. Yeah. Yes. My lord, what is more important, I'm sorry, my lord, there is, after the appeal which was filed directing the requiring authority to pay, again a demand was made and we paid further sum of about 4 lakhs. My lord, so as you are demanding, we are paying, my lord. We're going on paying. It's lying with the state of West Bengal. It's very important, my lord, that you appreciate. So special leave petitions are filed. My lord, matter comes for hearing before Justice Gogoi, the Chief Justice, my lord, of the Supreme Court. And my lord, he understands what is going on. And we say, we are not in possession of the land. What we will do? Return. You have been asked to direct to return. You return it. What are we going to do? So, my lord, Justice Gogoi, there's an order, says the Supreme Court, says, no, we'll ask the, this is very unfortunate that the Eastern Coalfield should have brought these things to the notice of the trial court instead of arguing adverse possession and all these things. Should have brought these things and says the district magistrate, you go and inspect and file a report before the Supreme Court. District magistrate goes and files a report. No, there is no mining. How can there be mining? I never took the land. It is paper possession. As interesting as it is and funny as it seems, that's when it came to me. And I said, this is not the end of the matter. So, and Millard says, this is the last final order of the Supreme Court disposed of in 2018. We have seen the report of the district magistrate. Nothing lies in these appeals. Appeals are dismissed. But if the state of West Bengal or the requiring authority want, they are at liberty to proceed under the 2013 Act, Fair Compensation Act. If you are liberty, meaning thereby, if you require again, you can have to proceed. End of the matter. So basically, I don't require it. State government holding, so all they have said, you take your possession, end of the matter, pay the money, whatever you have collected, matter would have rested there, finished. No. My lord, suddenly, after 2018, I get a notice that you have to pay more money under the 2013 Act and calculating, my lord, about 20 lakhs. I said, what? I mean, I do not require the land. How does the 2013 Act come into being? You have not, in 2019, a fresh acquisition notice has to take place, provided I require. So, my lord, this is the short point, my lord. It goes to learned single judge. A writ petition again is filed by the landowners. You have to pay now under the 2013 Act. And so state government says, what can we do? They are not giving us the money. So how can, so direction is there. No, we have to comply the order. And on the first day, without filing of affidavits, matter is disposed of. You comply with the order of the Supreme Court. And because we have lost all matters. This is the short point. In 1 minute, I will show is all absurdity. If
Mr. Dattu, for the state?
No.
No.
This is absurd. My lord, the first day matter is disposed of without filing of affidavits, and my whoever appeared on behalf of ECL doesn't. When it came to me to prefer appeal, I said, "What is all this happening? You pay direct state government my money, lying sitting. Of course, they won't pay because the exchequer is not there. But do I have to pay?" Justice Mulli, that is appreciated, my lord. It's so amusing.
Have you made any demand in the meantime to give the possession of the property?
Yes, yes, my lord. They have made demand in 2021 again. And what demand? It's lapsed. And they're meaning demand under the old pending, that pending of 1976, but under the 2013 Act. Is it possible? This is a short point your lordship fixes, but the main thing is, how can the matter be decided without affidavits? A mandatory order like this.
The learned judge did not decide anything.
No, that's what the direction is given.
Yes, in terms of the division bench order.
What is the division bench order did not direct? And after that, on the basis of that order, demands are being made.
That you show us the division bench
Yes,
order.
yes,
You
my
show
lord.
us the
My
Supreme
lord,
Court order.
I said it is lapsed. And the writ petition enclosed certain demands, extra demands under the 2018 Act.
Suppose there are provisions,
Yes.
it may not have lapsed, theoretically speaking. Because as you know, under Act 2 of 1948, that could have been converted into a acquisition proceeding under Act 1 of 1894.
Yes, my lord.
By Section 9A.
Correct, my lord.
If that was done, and if as on 1st January 2014,
yes,
the acquisition proceeding was pending, if that was saved by Section 24 of the 2013 Act,
yes,
then it is possible that the proceedings continued under.
My lord, there is a declaration of the by the High Court that it has lapsed.
There's a declaration.
Of course, that's what I told your lordship. The division bench said that.
I have not seen any of the orders.
No. Division bench said it has lapsed. Return the land. My lord, I am aware of Section 24. 24 does not, my lord, it's just like defying the order of the, my lord, 24 is a peculiar section, no doubt about it. It says if no award is passed.
The court has said then no question.
Yes. So will it overcome? Pertinent, my lord, Justice Banerjee has asked, yes, 24(1) did strike me. Firstly, 24(1) talks about not acquiring under the 1940 Act. Correct. It talks about 1894. Secondly, most important and fundamental, if High Court and confirmed by Supreme Court says it has lapsed, what statute will come?
Correct.
This is the short point, my lord.
You please serve another notice on the state.
Meanwhile, I have also filed an application for the writ court saying that how can you make a demand under the 2013 Act demanding extra money? You have no jurisdiction. The Supreme Court has decided.
It has now become a fight between you and the state.
No. What's worse, when they want more money? My money is lying with them. Why didn't they pay them?
Issue. This appeal is directed against a judgment and order dated September 26, 2023, whereby the writ petition, whereby two writ petitions of the private respondents herein being WPA 15811 of 2022 and WPA 20275 of 2022 were disposed of by a learned judge of this court. Stop. The present appellant were party respondents in both the writ petitions, Stop. Being aggrieved. They have come up. Have you filed 2 appeals or 1 appeal?
No, my lord, this one appeal from the impugned order, your lordship has noted 2.
Impugned order disposes of 2 writ petitions.
My lord, we have just filed in WPA 158111.
You were not parties to both the writ petition.
I have no idea. My lord, I have no
Because
idea.
then technically speaking, you would have to file 2 appeals.
My lord, I was not in the trial court also.
I'm not.
No, not my
Oh,
trial.
no, none of you were there.
No, my lord.
Find out, find out.
Yes, we will, my lord. In fact, the advocate on record was also changed to Parthobo, my lord, in the, after the.
So you have come up from.
My lord,
WP?
the impure, you see the memorandum of appeal, my lord? But since your lordship has,
15811.
yes, my lord.
কি বলেছি বলতো? হ্যাঁ, তারপরে।
কোথায় বলেছে যে ল্যান্ডটাকে ফেরত দিয়ে দিতে হবে?
Were not বলেছি, very not বলেছি। The present appellants have come up against the aforesaid order insofar as the same disposed of WPA 15811 of 2022. Paragraph.
My lord, may I show something? If your lordship permits one portion. If you see the
We are
impugned
not, we are just recording that you have started submission.
Oh, acha.
Nothing, no order, nothing.
The lordship said something about that there is no direction given mandatory direction in the order except comply. No, my lord, there is something.
No, it's necessary funds, we have seen.
No, it is saying in view the writ petition is disposed directing requiring body, that is Eastern Coalfield, to comply with direction of division bench and vacate the land in question. No, what vacate? It is in possession of the state government. This is.
Stop. The operative portion of the impugned order reads as follows. করে এখান থেকে করে দেন। এই internal page 2 bracketed portion 2 or 3. Paragraph. The appellants say that they are not in possession of the land in question. Stop. They never took physical possession. Stop.
No, my lord, it will be wrong because paper possession was given
They
in long
never
back.
took physical possession, although papers may reflect that possession was handed over to them. Stop. No mining activity was ever carried on in such land. Stop. Hence, comma, the question of the appellants putting the state authorities in funds for paying compensation to the landowners cannot arise. Stop. It has been held by the court that the acquisition proceedings lapsed. Paragraph. The state, neither the state nor the private respondents are represented today.
My lord, I had already put funds with the state in terms of the old act.
Stop. That's তার আগে লিখে দাও যেখানে বললাম does not arise. Stop. However, comma, in terms of earlier demands made by the state, comma, the appellants have paid substantial sums to the state. তারপরে লেখো neither represented. Stop. Let this matter stand adjourned and be listed again on.
Your lordship's convenience.
Tell us next week someday.
Yes, my lord, whenever.
Thursday, next Thursday. আজকে Thursday.
As per your lordship's convenience.
Next Thursday date টা দিয়ে দাও.
My lord, there is a question because I've been directed to make payment as per the demand made. I mean, that's the reason why I was asking for.
আচ্ছা 1 month is gone long back.
I know because
কি বললাম Thursday করে দিয়েছো. Stop. Let fresh notice be served on the state and on the learned advocates for the state and the private respondents. Paragraph. Since in our opinion, a prima facie arguable case has been made out by the appellants, comma, let no further effect be given to the order impugned for a period of 2 weeks from date bracket दिए दो, or until further order, whichever is earlier.
The affidavit service is kept
Service
on
to the-
record.
Serve fresh notice, madam, on state advocate and
My lord, the
yes,
my lord,
and private respondent.
For this, my lord, the item number 11.
Yes,
The passport, my lord, it was my passport.
yes.
My lord, you lost direction to bring the original record. We have got the original record. And my lord, tomorrow I have some personal difficulty, my lord, you lost it on Monday. I shall communicate Mr. Kamal.
Who are the other advocates?
I shall communicate Mr. Kamal.
11 not this week করে দাও।
Next week.
স্যার স্যার আছে
Next week. সোমবার। ঠিক আছে। তোমরা আছো?
Lordship, item number 19, Lordship, please to pass order to extend the evidence opposition to file, Lordship. I am for the municipality, Lordship, in the matter, Lordship, kindly my name will kindly be recorded, Lordship. in That matter. উঠে দাও।
Yes.
Item number 19.
বলে দাও কে ছিল?
তন্ময় বাবু।
My lord,
Grateful, Lords.
my lord, may I be permitted to mention a matter for inclusion of the matter in the list, my lord?
Why now, madam? Mentioning time is in the morning.
My lord, it was a order of division bench, your lordship.
This bench.
Lordship.
Oh, কি matter দেখো তো?
My lord, I shall hand over the order copy. It is a contempt application, your lordship. Your lordship has passed an order in the month of October 2023, your lordship. They have failed to comply with the order, your lordship.
My lord, may I allow to mention for contempt application for lordship? Grateful, your lordship.
My lord, may I be permitted to mention one contempt application for inclusion?
This bench.
My lord.
এই নাম দিয়ে দে, নাম দিয়ে দে।
নামগুলো
In fine, we find that the impugned constructions raised by Sonali, Shukdev and Shipra are all unauthorized and incapable of being legalized as per the applicable building rules. We therefore find no infirmity in the conclusion reached by the learned single judge. We agree with the such conclusion, maybe for different reasons as indicated above. We affirm the judgment and order under appeal. Consequently, all the three appeals being met 4-2 of 2023, met 101 of 2023, and met 69 of 2023 are dismissed. There will be no order as to costs.
My lord, then
My lord. Your lordship stands, my lord. Everybody. Everybody. না আমার কি বলার আছে জজের অর্ডার এই একটা কমন অর্ডার হলো একটা কমন জাজমেন্ট হলো
একটাই কমন যাবে। চলো কি হলো?
সব সব
হরিয়ে মাধব, সবটাই হরিয়ে মাধব হয়ে গেল। যাক, যাক। করে নে, যা।
Political side, item number 1.
One lordship, I beg to appear on behalf of the petitioner. Madam, straightway drawing lordship attention, it is, my lord, not complied, rather flouted, my lord, though there is very specific word, my lord, being used by this honorable court, page 17. May I read, my lord? 17. Order of this honorable court starts from page 14. I am drawing lordship attention, page 17, direction portion. After hearing the rival contention as raised by the learned advocate for the parties to the instant appeal, the court considered that justice would be sub if the KMC is directed to supply of the spot inspection report at the present appellant well beforehand.
Then we requested you to supply the copy of the.
No, well, directed.
Yes, applied, but he is partially correct that on the date of hearing.
That rule will be kindly be issued, my lord.
Secondly, my lord,
well beforehand.
The person who against whose name has been this application has been meant, he was not the hearing officer. Hearing officer, the executive engineer of the concerned.
Served on you.
Yes, my lord.
One copy has been served.
Last occasion, my lord, lordship.
We granted leave to serve.
Yes. Yes. My lord.
Yes, but now you have got it, Mr.
No, my lord, kindly see, is directed to supply a copy of the spot inspection report to the present appellant well beforehand, before the next date of hearing, and in the event same is not possible, positively on the next date of hearing, my lord, they may adjourn the process and, my lord, hand over all those papers and documents to counter us, my lord, in an appropriate manner. And at the same time, this is not inspection report also. I am coming, my lord. Lordship, kindly see, my lord. Page 25 is the order. My lord, they have actually prepared the order prior to hearing, my lord. On the said date, 20th February, only hand over the copy of the order. Lordship, kindly come to, my lord, page 25. The order itself. Whether that particular construction is building.
Page
25. Order passed by the special officer building or, my lord, the executive engineer. He is the delegate of municipal commissioner. Possibly, my lord, he is passing the order.
You are too fast, at least for me. Go a little
slow.
slow.
My lord. True, my lord. In the scenes.
Our order was passed on.
My lord.
8th of February. So,
13th February.
13th February.
Page 14.
When did they fix the meeting?
20th. When I'm moving this honorable court, at that point of time, it was a pre-scheduled date on 20th February.
Very good. So 20th February you went.
Went.
Before that, they didn't give you a copy of the spot inspection report. On 20th February, they give you a copy of the report.
At the same time, copy of the order.
Order copy.
Yes.
Hey, that's okay, na?
And the direction was otherwise.
We have followed. We had directed this report to be made available to you earlier so that you could counter it.
Yes, my lord.
Yes, this is not right.
So
one thing.
Positively on the positively on the next date of hearing, so as to afford the present appellant a reasonable opportunity to counter such spot inspection report. So, in the event it was not supplied earlier, positively on the next date of hearing, so as to afford a present appellant a reasonable opportunity to counter such spot inspection report. So what you did?
After your lordship's order, we have again caused an inspection on 15th upon prior notice.
Yes. Then
15th, on 15th. Now thereafter inspection report was prepared.
Well,
and it was supplied on them on 20th.
And same day order.
No.
Same day hearing was made. Hearing was fixed. Order was passed after, but hearing was made on giving that particular date. Order was passed.
But possibly my learned friend was.
Order also supplied.
But Mr. Mojumdar.
Karina, what have you find that you invite your own problem?
Self-designed. It's not. It's inviting problem. It's designed.
Why? It has not been served earlier. If it is served on a particular day, That is on the day of hearing itself. What is the predicament in fixing a day of hearing day after tomorrow or day
Kindly,
after the
kindly set aside the order and give a fresh hearing. It is better.
Direct executive.
Fresh hearing.
Please see also page 27.
Technically, this is contempt.
Yes, ma'am.
Technically, this is contempt against respondent number 2.
Yes.
Normally,
Commissioner.
No,
commissioner is not a commissioner.
Direction municipal authority.
No, I strictly object regarding the contempt application against the commissioner.
He is at the helm of affairs, chief executive.
7, sir.
One more, my lord,
The inspection report.
My lord, kindly see.
This is the inspection.
Kindly see, my lord. This is dated on 15 January 2023. He said after the order was passed, there was further inquiry. This was previously done, my lord. This was in their pocket.
What is page number 27?
27 is, my lord, they are claiming this is the inspection report. Our humble submission, this cannot be.
What is the order?
May I just page
My lord.
27, 2 paragraphs from page 27.
Not required. Mr. Mojumdar,
Yes, my lord.
please, where is the order?
And the order is previous page.
Order is previous.
20th of February 2024. Now this is dated 16th of January 2024 with a purported enclosure which is not supplied to me.
Where from we'll get the date?
Not it's signed on page 27. And the order dated page 26 is also signed with a date.
So at present you are aggrieved with the order dated.
I am aggrieved by 20th February 2024.
No, he is not aggrieved by the order. He is aggrieved by that inspection of a report not beforehand supplied. That is his grievance.
Hard learned advocate for the parties. Stop. On behalf of the petitioner, attention of ours is drawn to.
One prayer, my lord, before I am, my lord, for kindly excuse me for interfering.
Where is our order?
Page 14. Page 14.
Let this executive engineer may be directed to consider the matter afresh on this self-same inspection.
Attention of ours is drawn to order dated February 13, 2024. The relevant portion of ours or our order is reproduced herein below in verbatim. Set out from paragraph 70. It is contended on behalf of the petitioner that though this court directed the alleged contemners to supply a copy of the spot inspection report well beforehand, before the next date of hearing, and in the event the same is not possible, positively on the next date of hearing, but the inspection report has been handed over on February 20, 2024, and immediately thereafter hearing was concluded without giving any reasonable opportunity to the present petitioner to counter such spot inspection report, which according to the learned advocate for the petitioner is utter violation of our earlier order as mentioned supra. Stop para. In course of his reply, learned advocate for the alleged contemners contended that after passing of the order by this court on February 13, 2024. A fresh inspection was conducted, which is why
On 15th,
on February 15, 2024,
upon prior notice.
upon prior notice, which is why delay has been caused in supplying the said spot inspection report. Stop. On perusal of the entire materials as placed before us, and after hearing the learned advocate for the contending parties, we find that no opportunity, no reasonable opportunity has been given to the present petitioners to counter such spot inspection report dated February 15,
Dated February 16th.
February 16, 2024, which is in complete violation of our earlier order. However, considering the fact that in the meantime, such inspection report has been furnished, has been provided, copy of. In the meantime, copy of such inspection report has been supplied by the alleged condemners to the petitioner. We set aside
সইটা কোন বলছেন দেখেন দেখিয়ে দেন একটু 16 সই করে দিয়েছে ওখানে 24 লিখেছে
and the order dated February 20, 2024 as passed by executive engineer within bracket C, building department, Bodo 1, Kolkata Municipal Corporation, in respect of premises number 33A Bonomali Chatterjee Street, Kolkata 7,02,000, Ward 005, Bodo 1.
That it is submitted on behalf of the alleged contenders that the order dated February 20 stands withdrawn and fresh order will be passed upon giving opportunity of hearing.
Upon compliance of the directions in the
Upon compliance of the direction.
only two things that I need to point out to your lordship.
Compliance of notice to both this petitioner as well as the private respondents, because he is the complainant.
Everybody.
No, I'm not. He's very emphatic to the complainant. But please have a look at page 27. But a 15 January 2023 inspection is referred.
And in view of the submission of Mr. Mitro appearing for the alleged contender, that it is placed on record, that it be placed on record that the order dated 22/2024 as passed by such and such may be treated as withdrawn. This court directs Executive Engineer C, Building Department, Bodo 1, KMC, to conduct a fresh hearing in respect of the aforementioned premises
On the basis of such inspection report.
This such inspection report is something not which we don't understand. No, please see page 27 once. No, I just
of the materials as placed as available before him within a fortnight from the day of passing of this order.
Kindly give 1 week more, within 21 days.
Within 3 weeks. Within 3 weeks from the day of passing of this order.
Upon a hearing to all concerned.
Upon notice to all concerned.
Upon notice to all concerned. Stop. What is to act on the server copy?
থাকে নরমালি থাকে তো what is to
What is to act on the server copy? With the aforementioned observation, the instant contempt application is dismissed.
Kindly keep it pending. Please have a look at two sentences from page 27. On page 27, please see. Now, Mr. Mitra is submitting that a fresh inspection was carried out pursuant to your lordship's order on 16th of February 2024. Please have a look at the second line of page 27. Inspected the aforesaid premises on 15/1/2023.
Yes, 15th was the date fixed for the inspection.
Order is passed on 16th of January 2024.
And signed is
15th January 23.
Order passed on 16 January 2024. Your lordship's order is dated 13th February 2024. And please see, there is a purported inspection report is enclosed mentioned. The first line in my representation is I have not received any.
Our order is dated, our order.
13th February 2024. No, this is trying to hoodwink with the court.
Explain করতে বল।
এটা কি দিয়েছে তাহলে ইন্সপেকশন?
Trying to hoodwink the court.
এটা আসলে কি দিয়েছে?
And there is a reference to an enclosure as an inspection report which was not supplied to me. The first thing I write back to the KMC is I have not received a copy of the inspection report. What are you talking about this?
We have been supplied these documents. Oh, it is well not 15/2, it is 15/1.
Then after the division line.
15/1/2023.
No, it is
24 হলো।
No, it is 15/1/2024. Mother kindly.
And what the submission advance was after your lordship's order of fresh inspection was carried out.
It is a letter written to all the parties giving a date of inspection. That is the letter. I'm giving a copy to him, Mother.
Not the sub.
You told us
Mother,
that after passing of the aforesaid order,
I tender apology, my lord. I completely misread the date at 15/1.
No, a wrong instruction was willfully fed to the learned counsel.
The instruction, my lord, instruction, it is fixed on 15/1/2020. Pursuant to the order of the perhaps the honorable single.
Kindly direct him to explain personally this conduct. And there is a reference to an inspection report having been enclosed, which has still not seen the light of that.
Just a minute, Mr. Mohan, let us take it.
Advocate for the party. On behalf of the petitioner, attachment of ours is not to order.
Right.
Element of portion of ours order set up. Is contained on behalf of the petitioner. As well as for directly the responsibility to supply a copy of this spot inspection report well beforehand before the next date of hearing. And in the event the same is not possible, positively on the next date of hearing. But the inspection report has been handed over on February 2024, and immediately thereafter, hearing was concluded without giving any reasonable opportunity to the petitioner to counter such spot inspection report, which according to the counsel for the petitioner is utter violation of our earlier order as mentioned. Next, in course of this reply, advocate for the alleged contempt was contended that after passing of the order,
এই পোর্শনটা বাদ যাবে। ওটা আমি বলে দিচ্ছি।
15/1 আমি 15/2 পড়ে
In course of his submission, Mr. Mitra, learned advocate for the alleged contemners, submitted that admittedly a delay has been caused in supplying the copy of the inspection report within bracket S square to the present petitioner. And such being the position, the order dated February 20, 2024, as passed by Executive Engineer within bracket C, Building Department, Borough 1, KMC, may be treated as withdrawn. এবার কি হলো?
Building hearing invested for the aforementioned of the materials available to him within a period of 3 weeks from the date of passing of this order. Upon notice to all persons.
তারা কিছু বলেছে?
তারা আমি কি বলতে Because of এটা বলে দিল যে কাটা যাবে। তারপর বলেছেন on perusal of the entire materials as placed before us and after hearing the learned advocates for the contending parties, we find that no residual of has been given to the petitioners to counter such participation report dated February 16, 2024.
Report dated.
On perusal of the entire materials as placed before us and after hearing the learned advocates for the contending parties, we find that no residual of has been given to the petitioner to counter such participation report dated
date of birth. Report within bracket S করে দিই।
Which is in complete violation of our earlier orders. However, considering the fact that in the meantime has been supplied by the alleged petitioner to the petitioner and the order dated February 20, as passed by the engineer building and if we have submission of
ওগুলো লাগবে না তাহলে তো আগে তো ট্রেজারার বিদ্রোহণ বলে দিয়েছে and in view of submission of
ঠিক আছে।
I tender appeal to waste your lordship's time.
So contempt application is disposed. ওটা ঢোকাতে হবে।
বলে দাও তুমি last paragraph বলে দাও in view of the stand taken by the alleged contemners, we take a lenient view of the matter and close the contempt proceedings. We take a lenient view of the matter and close the contempt proceedings.
But last year, I tried.
I am grateful to you.
This is appearing after service, Miller.
You are appearing
for the alleged contempt. Miller, do Mr. Bandyopadhyay and Miller Mr. Roy.
All three of you for the same alleged.
Miller, there is only one Miller alleged.
One.
We are one.
How many contemners are there?
Two.
I'll just check. Miller, we are appearing for one now. We are appearing for the alleged contempt number 1.
Miller, the issue pertains to.
Mr. Rajgupta, now they have appeared. Let them file an affidavit. Let them explain. Let them file an affidavit. But 4 learned counsel for 2 alleged contemptors.
Miller,
for 1 alleged contempt.
1 alleged contempt. Aggravated contempt.
Miller, I will show Miller there is nothing. This is just Miller and
Miller, only Miller, content number 2 has not appeared. Miller, issue a rule Miller on the content.
Yes. Service.
Service Miller I have given. I have service.
It has been affected.
Yes, yes. my lord. It was done on the day my lord passed the order, that evening only.
Shubhadeep Roy and Amit Shital Kujur.
Yes. Yes, delivered. Item delivered.
Both. Particularly number 2.
Content number 2, item delivered, page 7.
What is his name?
My lord, Amit Shital Kujur. Addressee, item delivered, bracket addressee. On 29th.
Esho? Affidavit of service filed in court today be kept with the records. Paragraph. Pursuant to service, comma, learned counsel appear for alleged contender number 1. Stop. Let affidavit in opposition be filed by the alleged contender number 1 within a fortnight from date.
May we have, my lord, 4 weeks, my lord. I personally have some difficulty, my lord, in the meantime, my lord. There is something, my lord, at home. So I personally.
This is where you put us in problem. How can we say no then? Nor can Mr. Dashgupta say no.
Mr. Dashgupta knows, my lord, my difficulty.
Within 4 weeks from date. So reply there to comma if any we filed within.
Milad, no issue, Milad. I know, Milad, the difficulty is that, Milad, the act of violation is still continuing.
That's
the
the filing of the suit. That suit will take 20 years now. So don't worry.
Very well. I'll leave it to you.
1 week. 1 week.
Then what gives me 2, gives me 2
weeks thereafter date gulo diye diyo. Huh? Paragraph. List the matter. 6 weeks hence, diye dao. 6 weeks hence, comma, whenever this bench is again available. অর্পণ মনে করে দিও একটা 6 সপ্তাহ বাদে বেঞ্চ করে দিও একটা paragraph. In spite of service, comma, nobody appears for the alleged contender number 2. Stop. It seems that the alleged contender number 2 has taken court proceedings very lightly. Paragraph. There will be a rule as prayed for against the alleged contender number 2. Stop. Returnable 6 weeks hence. ওই ডেটটাই দিয়ে দাও যেদিন আসছে ম্যাটারটা হ্যাঁ প্যারাগ্রাফ the petitioners shall put in কি বলে ওটাকে special messenger fees with the department within by next Monday by next
11 তারিখ ঠিক আছে
by 11 by March 11 March 12 by March 12 comma to expedite service of the rule on the alleged contender number 2.
My lord, one more thing, my lord, we could not, my lord, file our vokalatnama. If my lord kindly grant us time, my lord, till tomorrow. Oh, fine. Minutes. Fine.
Learned advocate on record representing the alleged contender number 1 will be at liberty to file.
It's already filed, my lord. Just now
Filed.
already filed.
Obliged.
Great. Now that the matter is over, my lord, to my humble understanding, my lord, filing of this contempt application is possibly an act of contempt.
Very good. It'll be an interesting argument.
No, of course by the litigant, sir. Of course by the litigant. That goes without saying. Grateful, my lords. Great.
Number 1.
এটা তো চলবে আর তো কিছু হবেও না Why is kite flying associated with Vishwakarma Pujo?
Vishwakarma is
You may take instructions from your client.
But this is the different Vishwakarma. And Lord, here we let Mr. Vishwajit Mukherjee come up with his response, and I'll respond to that later in reply. The turncoat method which I was employing, my lord, in Rofina Alam's case will not take us much further here. Let him take up those points. Immediately I'll reply and I'll rejoin. My short point was the tenant has a right to file the tenant should be a person, can be a person aggrieved within the meaning of section 400 subsection 3 of the Act. Any person who has a proprietary interest in respect of the property in question would be a person aggrieved within the meaning of the Act. If an order of demolition has been made which affects inter alia the portion occupied by the tenant, there is a latent obligation under the statute that anyone connected with that order, that particular portion which is directed to be demolished, be served with a copy of that order. That service need not be by hand. That service may be by affixation on a conspicuous part of the premises. But whatever it may be, because there's a right of appeal, the persons in the premises, including all tenants, need to have a copy of the order available to them, and they need to have a period of 30 days within which to carry an appeal before the appropriate forum. Whether or not a person aggrieved, a tenant can be a person aggrieved, is something best left to the forum. This, my lord, I had, my lord, submitted on the earlier occasion, and my lord kindly considers this is the law relating to the forum being the appropriate authority to decide who's the person aggrieved. And my lord, may I just cite 1952 volume 1 SCC, page 798.
52 volume 1 SCC.
My lord, that's 52 volume 1.
There was no SCC in 52.
No, my lord, they have redone it again.
Had they? It started from 69 originally.
Yes, 69, the printed version. Then there was SCC online. Then they took SCC online back till earlier. And now they have an SCC citation for this as well.
Achha. But is it available in book form, bounded?
No, I found it not from the net, from the SCC, official SCC online site. So what they've done is the soft version, they have subsequently also given it, my lord. 1952, volume 1, SCC 798. Please consider.
Who is?
My lords.
In this judgment, what has been decided? Who is?
The forum concerned would be the forum which would decide who is a person aggrieved for the purpose of carrying an appeal before it. My lord.
Relevant paragraph?
Yes, Lord. Kindly bear. Please come to paragraph 13. This is, my lord, a celebrated principle. Yes. Paragraph 13 of the SCC online reports. This is 1952 1 SCC 798. Equivalent citation is 1952 SCC online SC 63. It was contended, may I just please note the paragraph 13. It was contended that no court of limited jurisdiction can give itself jurisdiction by a wrong decision on a point collateral to the merits of the case upon which the limit of its jurisdiction depends, and that the questions involved in the appeal before the respondent were collateral to the merits of the case. Now, my lord, here, my lord, this part is important. This has now been made part of the Indian law. As pointed out by Lord Escher MR in R versus CIT, the formula enunciated above is quite plain, but its application is often misleading. The learned master of the rolls classified the cases under two categories thus, when an inferior court or tribunal or body which has to exercise the power of deciding facts is first established by Act of Parliament, the legislature has to consider what powers it will give that tribunal or body. It may in effect say that if a certain state of facts exists and is shown to such tribunal or body before it proceeds to do certain things, it shall have jurisdiction to do such things, but not otherwise. There, it is not for them conclusively to decide whether that state of facts exists, and if they exercise the jurisdiction without its existence, what they do may be questioned, and it will be held that they have acted without jurisdiction. But, and this is important, my lord, there is another state of things which may exist. The legislature may entrust the tribunal or body with a jurisdiction which includes the jurisdiction to determine whether the preliminary state of facts exists, as well as the jurisdiction, and on finding that it does exist, to proceed further or do something more. When the legislature are establishing such a tribunal or body with limited jurisdiction, they also have to consider whatever jurisdiction they give them, whether there shall be any appeal from their decision, for otherwise there will be none. In the second of the two cases, I have mentioned it is erroneous application of the formula to say that the tribunal cannot give themselves jurisdiction by wrongly deciding certain facts to exist, because the legislature gave them jurisdiction to determine all the facts, including the existence of the preliminary facts, on which the further exercise of their jurisdiction depends. And if they were given jurisdiction so to decide without any appeal being given, there is no appeal from such exercise of their jurisdiction. The tribunal constituted to hear appeals under Section 24 has been constituted in these terms. Any person aggrieved by an order made under Section 7, Section 16, Section 19, or Section 38 may prefer an appeal in such manner and within such time as may be prescribed to the custodian where the original order has been passed by a deputy or assistant custodian, to the custodian general where the original order has been passed by the custodian, an additional custodian, or an authorized deputy custodian. Now, Lord, this is important. Like all courts of appeal exercising general jurisdiction in civil cases, the respondent has been constituted an appellate court in words of the widest amplitude, and the legislature has not limited his jurisdiction by providing that such exercise will depend on the existence of any particular state of facts. Ordinarily, a court of appeal has not only jurisdiction to determine the soundness of the decision of the inferior court as a court of error, but by the very nature of things, it has also jurisdiction to determine any points raised before it in the nature of preliminary issues by the parties. Such jurisdiction is inherent in its very constitution as a court of appeal. Whether an appeal is competent, whether a party has locus standi to prefer it, whether the appeal in substance is from one or another order, and whether it has been preferred in proper form and within the time prescribed, are all matters for the decision of the appellate court so constituted. Such a tribunal falls within class 2 of the classification of the Master of Rolls. In these circumstances, it seems to us that the order of the High Court of Punjab that a writ of certiorari could not be issued to the respondent, quashing the order of 13th May 1950 was right. We are further of the opinion that none of the contentions raised has any merit whatsoever. Now, my lord, pausing here for a moment, please consider, my lord, the provision for appeal here and the provision for appeal that was there before the Honorable Constitution Bench. 400 subsection 3, my lord, will kindly take a look at, my lord. please be satisfied, my lord, when I submit that the nature of the appellate provision in 400 subsection 3 is akin to the nature of the appellate provision mentioned in paragraph 14. There are no further special circumstances given here. Please see, my lord, paragraph 14, the appellate provision. In such circumstances, my lord, it would be for the appellate forum to decide as to whether a party would have locus standi to prefer an appeal, that is, whether a person would be a person aggrieved. Therefore, at the initial stage, on the assumption that he may not be a person aggrieved, one cannot prevent any person who claims to be aggrieved from having access to the tribunal. In my respectful submission, therefore, my lord, for the purposes of 400 subsection 3, it is necessary that any person who has any proprietary interest in the subject matter of the order of demolition be given a copy of that order and be permitted to carry an appeal. Lord, these are my submissions.
The law is born out of the facts. Law is not a journey in the shade outside the tempest created by the facts, because law is not born on its own, but it has to have a factual background. But before I proceed further, there were two writ petitions concerning the same building. The building is around G+4. The entire building is illegal without any sanction plan. The first writ petition is numbered 7911 of 23. And in this proceeding, my learned friend is seeking a leave to challenge.
First writ petition
is 7911 of 23. I'll just place the
7911 of 2023.
That writ petition was disposed of by an order dated 4th of July 2023 by the trial court, wherein the writ petitioner sought for implementation of an order of demolition. That was carried in appeal before your lordship. Your lordship disposed of that appeal. I'll soon place it. Thereafter, another proceeding started, that is petition number 3189 of 23. And that was 3189 of 23. That was disposed of by the Honorable Trial Court in view of that already a direction is there for demolition, which has been affirmed by the division bench. So there nothing remains to be decided in the second writ petition. So the direction was given, the corporation should implement the order of demolition. These are in nutshell the facts. After all these proceedings, the tenants have come up with this application seeking leave to file an appeal challenging that order of 30th August 2023. Though already an order of 4th of July 2023 is holding the field. Now, my lord, I would draw my lord's attention immediately to your lordship's order at page 21
of the writ petition
of this of his, my lord, his application leave to file an appeal and stay.
No, page 21 of
My lord, can number 2 of 23.
Stay application.
Yes.
If your lordship is kind enough to take page 21. This is the judgment delivered by the
It is leave to prefer appeal.
division bench of this court relating to the same very property. Malad, the third paragraph. This appeal is directed against.
Just a minute, sir.
Malad, page 21, annexure P2.
Page 21 of Can 1.
Can 2, Malad.
Oh, I see.
I'm sorry.
Can 2, yes.
Malad has got Can 2. Page 21.
Just a minute, sir. Yes, I got it.
Yes, I'm placing from the third paragraph. This appeal is directed against the judgment and order dated July 4, 2023, whereby the repetition of the respondent number 6 hearing being WPA number 7911 of 23 was disposed of. The present appellants were respondents number 8 to 11 in the repetition. The repetitioner approached the learned single judge alleging illegal unauthorized construction in premises number, note the premises number, at the instance of the private respondents in the repetition. The repetitioner further complained that the Kolkata Municipal Corporation was not taking any step. Before the learned single judge, it was submitted on behalf of corporation that on detection of unauthorized construction at the concerned premises, steps have been taken to initiate proceedings under Provision 400 of Kolkata Municipal Corporation Act. And steps have already been taken for demolition of the unauthorized construction. It was further submitted that a substantial portion of the unauthorized construction structure has already been demolished. Whatever has been demolished, my last instruction is that has been reconstructed. The learned single judge observed that from the report of the corporation that was filed before her ladyship, it was not clear as to whether entire unauthorized construction has been demolished or not. Accordingly, the learned judge disposed of the repetition by directing executive engineer of the concerned borough to take steps for demolition of the entire unauthorized construction at the earliest, if not demolished in the meantime. Being agreed, the private respondents in the repetition have come up by way of this appeal. The primary grievance of the appellant is that notice of the proceedings before the single judge was not served upon them. The learned advocate says that the address of the private respondents, as mentioned in the first title of the repetition, correspond to the address of the premises where the alleged unauthorized construction was being laid. It was a building under construction and nobody could reside in that building. Hence, wrong addresses of the private respondent have been mentioned in the first title. Mr. Nayak, learned advocate of the corporation, points out that the address of the premises where the unauthorized construction was being made is different from the address of the private respondents mentioned in the first title. In any event, he says demolition work is almost complete and is likely to be completed by the end of the day as per the instruction. Learned advocate for the appellant says that the appellant should be given at least a hearing before the demolition is completed, although there is no sanctioned building plan. Notice. The appellants intend to apply for regularization of the unauthorized structure. Thereafter, your lordship, we have considered the rightful contention of the parties. It is not in dispute that the improved construction was raised by the appellant without there being any sanctioned building plan. It is our considered view that citizens who take law in their own hands make constructions without obtaining prior sanction from the competent authority deserve no sympathy of the court. The law generally does not contemplate making of construction without prior permission and then apply for legalizing the same. People who indulge in illegal construction without obtaining prior permission from the appropriate authority are reckless
Very fair.
No, always. Mr. Mukherjee is
Very
very,
fair, fair.
very, very fair. My lord, that by very necessary implication does not mean I am unfair.
Yes.
That kind of argument he is.
একটু রসিকতা করলো।
Yes, sir.
Now, my lord, the law, so far as this concept of proprietary, whether any right is there or not of a person apropos a illegal construction, has already been set to rest. My lord, the first judgment is that of Maula Works Abid Hossain, which your lordship gets the first page mark, and your lordship takes. Yes, sorry. It is
Running page 7.
Basic paragraph. This is reported in 2001 CHN, page 4. Now, I would kindly take paragraph 12 of that judgment, which your lordship would get. At running page 15, paragraph 12. I am answering his concluded statement that I have a proprietary right in respect of that illegally constructed portion of the building. Now your lordship would see what this division bench has said. It is true that a right to property is recognized as a right of a citizen in the Constitution itself. A citizen may be deprived of such right only by the authority of law. This right to property cannot be construed in abstract. A building erected by a person who owns the land or who is authorized to erect a building on a piece of land has a right to the property in the building erected on such land. If a person erects a building on a land which belongs to public, he has no right to property in the building. Similarly, a building must be erected in accordance with the sanction, as your lordship has held, in respect of the same very building. If the building has been erected without sanction, such erection being an illegal erection, no right to property flows therefrom. If no right flows therefrom, the consequent is also true. No remedy also follows. Remedy follows a right. Remedy always follows a right. There cannot be any remedy without a right.
So according to you, what Mr. Banerjee argued, that he has been deprived of the right to appeal. According to you, since he has got no right to the property, he has no right of appeal. It is your contention.
In view of the law settled by this court, it's not. I am submitting anything, my lord.
Yes.
Mr. Mukherjee, the same logic should apply to the person responsible then. Why should he be given a right? Why has the section given him a right of hearing? It is illegal construction, no proprietary right. Why then hear even the PR?
That's exactly what your lordship has held.
Why even hear the PR? Such person.
My lord, the section has been, it has been clarified over here, where the hearing comes, where who should be heard, and in what circumstances he should be heard. Your lordship is very clear in that page, judgment of your lordship's division bench, which I have placed at page 21. It is exactly in the lines of what this division bench has held in Abid Hossain, Maulawaks. And similarly, a person who is authorized to erect a building in accordance with sanction erects a building in excess of sanction or contrary to the sanction to the extent the erection is beyond sanction or contrary to sanction, the person cannot be said to have any right to the property therein. But there are two situations are conceived of in section 400. Your lordship is aware of. One is where a detailed hearing has to take place, 1, 2, 3, right of appeal. And other is subsection 8 of section 400, where there is no notice, nothing of that sort. You go and demolish. What has fallen from your lordship, that I could have taken in a structure like this, subsection 8 of 400. But corporation here has proceeded in terms of 401, not in terms of subsection 8 of 400. But while deciding a case which arose out of subsection 8 of 400, the court made this observation in respect of the construction which has been made contrary to a plan or without no sanction at all.
Mr. Mukherjee, what is troubling me is probably one may think of two types of property rights. One in a loose sense and one in a broader sense. One protected by law, one maybe not protected by law. Whenever a property comes into existence, be it illegally or legally, the right in that property must vest in somebody. It can't be in vacuum. The ownership cannot be in vacuum. If that be so, even in respect of an illegal construction, some property right in some sense is there, may not be protected by law. Think about it. We are exchanging our thoughts. So, we'll have to see. You are placing a division bench, we'll have to see. We'll have to consider.
Well, first is your lordship's division bench, which is at page 21.
We may have been wrong.
Now, my lord, the last part of that paragraph 12, last 3 lines.
Just to add a bit to that thought for Mr. Mukherjee.
Mr. Banerjee,
But I-
please allow, please allow.
Absolutely.
No, not now. Yes.
First line of paragraph
Yes,
12.
yes, yes.
First line.
In the instant case, we are considering totally unauthorized direction for the same is either without sanction or in contravention or contrary to or in deviation of sanction. Here is a case, what the court was considering, a case where it was without any sanction. Your lordship, in respect of the same very building, has considered at page 21 without any sanction. The court in Molavaks was also considering a case where it was without anything. In those circumstances, court has held that no right flows, either legal or constitutional.
Why give a hearing at all then? Why is it necessary?
Not, that is what I am saying.
Then why has 400 subsection 1 said that only after hearing such person?
Well, the question is, at the threshold, the corporation has to make its mind. Because they go inspect, they find, then they proceed. They have to make a mind whether they should proceed under subsection 8 of 400. No question of any hearing. I can straight away proceed under subsection 8 once I find an entire 5-storied building is without any sanction. But in spite of that, finding that it is tenanted, people are staying, they gave notice to the person responsible or such person at whose instance the construction has been made. It is not my learned friend's case. My learned friend is very candid. He did not say that I have constructed or I will not come within the ambit of subsection 1 of 400 for which I can seek a hearing. But that person aggrieved appearing in subsection 3 of 400, I think is being stretched too far. If that is the interpretation sought to be given by my learned friend, my lord, there would be no end of the proceedings. Henceforth, for all the illegal construction, I have to go, find out, hunt out, go out for a witch hunting and give notice. If that is the verdict your lordships give,
Mr.
that would be binding on everyone.
No. You need not hunt out everybody. Just paste it on the walls.
If nobody responds to that,
Fine. Your obligation ends there.
and
That is public notice.
here, when he says he is holding some proprietary right, he must have got it from someone because he is not the owner of the land. The person from whom he has got it,
Let's say possessory right. He is in possession.
he got it from someone that XYZ had noticed. And when he finds that this would be the list of person who would be affected.
So it's difficult for me at this juncture, at least subject to hearing you further, to accept that I am in occupation of a portion of a building with my family. Now you will come and demolish it, and I will have no opportunity. I will not be considered to be a person aggrieved. What does grievance mean?
Case to case it might differ. Here I am proceeding in terms of an judgment of 4/7/23, which was affirmed in appeal, thereafter notices that is not under challenge anywhere thereafter.
What is affirmed? That it is an illegal construction.
Not only and with a direction, coupled with the direction that the corporation should proceed.
Yes, but at that juncture, nobody came before us to say that I am residing there. I am also a person aggrieved. We did not know that.
At that point of time, your lordship's order records that it is under some portion is under construction. The entire building in its entirety, at that stage we went and sought to demolish. Whatever has been demolished, subsequent has been built up. Today,
That's a different thing.
yes. Now, my lord, so far as this judgment is concerned, I am only placing paragraph 12. Thereafter, there are 3 judgments.
Practical.
Yes.
Already the word starts with the words. From a cursory glance over the said proviso, your lordships were deciding subsection 1 of section 400, on which the appellant has placed his argument to a great extent. It appears that the third proviso does not include, nor is meant to include, all unauthorized construction irrespective of their nature and extent, but is confined to minor unauthorized construction or execution of any minor work without sanction or minor deviation from the sanctioned plan. So your lordship was considering again a factual situation which was what could have been allowed, what could have been done. Now, what will fall for determination whether a 5-storied building could be considered to be a minor deviation or a construction of a 5-story building without a plan could be considered to be a structure of that type. As such, the said proviso does not relate to a huge or massive unauthorized construction or erection, but the same relates to only minor erection or minor deviation, etc. The appellant has utterly failed to show that his unauthorized construction is merely a minor one. Then, my lord, would kindly take paragraph 21. I do not want to trouble your lordship with the provisions of the law, but the bear on the facts because the facts are very simple. A total building unauthorized portion has been sold out or rented out or leased out, and they are the occupier of those portions in the entire building which is unauthorized. Now, paragraph 21. From the above, it is crystal clear that the third proviso to section 400 of section 1 of the Act 1980 and the regulation of 2015 formulated by virtue of the said proviso, that is AMC regularization of building, regulation 15, deal with minor unauthorized erection or work or minor deviation, etc. They do not include any construction other than minor construction or erection. In other words, to avail of a benefit as provided in the third proviso to section 401 or of the building regulation and regularization of building, regulation 15, the appellant is to show prima facie before the appellate forum that his erections were minor in nature, which can be sanctioned by the special officer building if he was actually allowed to appear before him. There is no material from the side of the appellant to show that he actually raised a minor erection or without construction without sanction plan. So, my lord, again that thing comes. So, what I ask a question to myself at the highest pedestal, if your lordship considers him to be a person aggrieved, what would he show before the tribunal? I ask a question again to myself with all humility. Because that regulation of 2015, he cannot take benefit of that because it is only minor. Even the section talks about, which your lordship has discussed in detail, talks about minor. Can again that question will come whether the structure of 5-story be considered to be a minor?
Mr. Mukherjee, when we are considering the question of who can be a person aggrieved within the meaning of subsection 3, we think generally, we have to think not only of a 5-story building without a sanction plan, maybe some deviation from a sanction plan. Let us take
from a sanction plan.
Let us take a scenario where there is some deviation from a sanction plan and demolition order is there.
Yeah.
There, to answer your query, what can the tenant say? The tenant can possibly try and impress upon the special officer that the deviation is not such as to warrant demolition order.
I fully bow down. I do not.
So conceptually, tenant can be a person aggrieved.
Provided what has fallen from my lord, I bow down again.
No,
if there is a deviation from a sanction plan,
so
it preconceives there is a sanction plan and there is a deviation from the same.
We are trying to evolve a concept. It can't vary from factual situation to situation.
I fully bow down to what has fallen from your lordship. I do not join any issue.
Well,
The factual background is
be a person. Yes, it can be. Sir.
You want to argue that in case of a minor deviation, it presupposes a sanction plan. Is it? In case of a minor deviation, it presupposes that there was a sanction plan. And when there was a sanction plan, there was some right to property. Right? And for deviation, that right can be exercised.
I cannot, whatever, even if he's a tenant, he's
But,
holding that
but according to you, Mr. Mukherjee, when there is no sanction plan, there is no right. So, aggrieved person cannot claim any right to preferential.
He cannot fit into that concept of aggrieved person, as it has just now fallen from my Lord Justice Banerjee. My Lord Justice Banerjee has just now said, we are thinking in a broader perspective. Suppose there is a deviation. The moment your lordships or I utter that word deviation from something,
it presupposes a sanction.
Yes, there has to be something which is sanctioned, and I have deviated
from which it has been deviation has been taken.
If that deviated portion comes into the occupation of a tenant, he has to be given a hearing. I cannot deny his right, because the structure itself is not entirely facts. That here the structure itself is without any authority. Its entirety is bad. But something I cannot be.
So no right has been. So no right has been created. That is your contention.
That is not my submission.
No. On the basis of the judgment cited.
Flowing from the judgment. It is flowing from the judgment. And it is always like this, Malad, the remedy follows the right.
So what you would say, Mr. Mukherjee, there cannot be any exhaustive or all-pervasive definition of person aggrieved. Whether a person is a person aggrieved or not will depend on the facts. Facts of the case.
Exactly the broader facts. I could not place it better than that. What has fallen from my Lord Justice Banerjee. As your lordship just now said, that we have to consider it in the broader facts. In the broader facts, some construction will come which are deviation from the sanction. One matter my learned friend is arguing before your lordship, where it is a 4-storied building. 3 stories are in terms of a sanction. The 4th story is without a sanction. And considers that apropos a construction without a
So again, coming down to the same thing as you said, in case of a totally illegal construction having no sanction plan, what possibly can the tenant say? The tenant can say something if it's a case of deviation and he is in occupation of the deviated portion.
Here in my compilation, I have not brought I have missed it, my lord, for which I apologize. Ultimately, I will place Esha Ekta, an appeal which went to the Supreme Court from a Bombay case, where beyond sanction, certain floors were constructed. After the promoter and the builder lost, the flat owners came up. before the court, Supreme Court. It ultimately came before the Supreme Court. Supreme Court said that ultimate authority is corporation. If they consider it well and good, the corporation said that no, there is no right. We will not. It has to fall. Then that was challenged. Ultimately, Supreme Court has said exactly the thing what it has, your lordship is. Now, my lord, I want to place paragraph 25 of this judgment of
Nirbal Dash,
where again your lordship has come to the basic point. Paragraph 25, which is your lordship would get at page 25, running page 25. However, a contrary view adopted by a division bench of this court in Abid Hossain Maulabak's was not considered by the learned single judge in the decision reported in 2007 SCC online Calcutta 6 months. A division bench of this court has observed paragraph 12. Again, paragraph 12. Because that is, my lord, the punchline of a right or no right.
There is previous judgment.
Yeah, because I started with the mother. Paragraph 12 of Abid Hossain, that is the punchline whether you have a right or you do not have a right. Whether a right flows from an illegal construction or it does not. If the right does not flow, the remedy cannot follow. If a right does not flow, the remedy cannot follow. Which is the character of the remedy is to follow a right.
Paragraph 27 at page 27 is also relevant.
Yes, I am grateful to my lord. From the above, it is crystal clear the appellant has no absolute right to claim that his valuable right of hearing has been violated by the corporation by taking steps under 408. That is, Malad, I did not place it because this is not a case under subsection 8 of 400. That was a case, Maulabak's was a case of subsection 8. Nirmal Kumar Das was a case of subsection 8 of 400. But since I have not gone there, but I am on a very basic concept, whether there is a right at all to claim a remedy. Whether there is a right at all to claim a remedy. Now, my lord, the second judgment I have referred to, that is also of your lordship's court, in the matter of Czar properties, which is unreported, and your lordship gets it at the third flag mark. Thank you.
Apnani judgment.
The next one is at page 40, the third, Czar properties. There are certain paragraphs in other one also, but I do not want to trouble because the basic point is this. Now, my lord, here I will be drawing my lord's attention at paragraph of Czar property, paragraph 20 and 22 at running page 54 and 55. The factual is that additional flows were constructed without any sanction. Then after this, your lordship would find at paragraph 22, page 55. The decision in HL 300 and others deals with the principle relating to the opportunity of hearing. In this regard, a reported decision of the Hon'ble Court 2001 1 CHL 4, that is again, my lord, the Mola can be referred to show that an unauthorized construction cannot vest any legal rights on the person who raised such construction. Or less, it can vest any legal right to a person who has come into possession of the same. If it cannot vest a right who has constructed, it cannot vest any right who has come into possession of the same. The above reported decision was not considered by the learned single judge in Chandra.
Sorry.
I'm not.
Again, I'm going back to the same thing because construction without any sanction is illegal. Absolutely without any sanction plan. Be it one story, be it one room, whatever it is. A construction made beyond the sanction plan, in excess of the sanction plan, the beyond portion is also illegal.
But it's under the
some cases, your lordship has
under the deviation.
In some cases, your lordship has made a distinction.
We would like to have that.
Deviated structure, whether that deviated structure can fit into a minor deviation or a major deviation. Because that Nirmal Kumar Das, your lordship has said that if the deviation is such, which is major in character, then, my lord, no right flows. Case might be legal.
Yes, but the law has given the corporation power to regularize or to render legal something that was initially illegal.
Yes.
If it is a minor deviation.
I found. And your lordship has consistently held so that if the deviation is of such nature which would fit into a minor character, then of course, and I say that you see, there is only one room on the roof with the toilet, with a privy and a kitchen, which I have come to hold, and it is illegal. But it does not offend any public interest or any interest at large. Again, the question will come, a 5-storied building in a broad daylight, everyone would see henceforth that yes, this man has somehow managed to get his building intact in spite of the legal proceedings.
Yes, next.
Again, your lordship has come to that basic point of Mola books. Now, my lord, the next one is Kolkata Municipal Corporation, Sheikh Muhammad Sharfuddin, which your lordship would find starts at page, it's the fourth flag, it starts at page 61. I would be drawing my lord's attention at page 63. The paragraph starts from on November 2023. Paragraph page 63, your lordship comes, paragraph 2. We are unable to show, my lord has taken note of, we are unable to show any indulgence to the occupant of the portions, occupant schema of the building which are unauthorized. End of the story, my lord. It's end of the, it's a blind end now. Any construction made without a prior permission of the sanctioning authority, that is KMC in this case, must be removed. The KMC Act has been promulgated in greater public interest and for a planned and efficient development of the city of Calcutta. No unauthorized construction can be allowed to remain on any ground, far less sympathetic grounds. In this connection, reference has been made to the decisions of the Zar property, which I have just now placed before my lord. Nirmal Kumar Das, that also I have placed before my lord. The order under appeal is set aside to the extent it requires KMC to initiate a proceeding under 400 subsection 1. Your lordship had been very drastic over here. Court said that you cannot proceed under subsection 8 of 400. You have to give him a hearing. That is subsection 1 of 400. Your lordship has set aside that order and said no question of any hearing. If it is unauthorized, it is unauthorized. And if it is unauthorized, it cannot stand on its on the ground.
Next.
These are the, on the basic law, your lordship has gone on the basic law. Now, my lord, this judgment, your lordship has the occasion. The next one is at page 65 of the compilation. This is the division bench judgment your lordship is aware of. I am not placing that. And if your lordship wants me to place that judgment, and it is again followed by a single bench of my lord Justice Jyotirmoy Bhattacharya, as his lordship then was. Then, my lord, there is a judgment, probably the last one, which says that a right has to be there for seeking a remedy. That's accepted principle. Those are my respectful submissions.
Ready. I can not start distinguishing here and now, if your lordship permits.
You think you'll complete today?
May not complete today, but I can start. I mean, I anticipated these arguments. I have come prepared with the reply. If your lordship permits me, I can start. If your lordship wants to me to address your lordships on any other day.
Yes, please continue. Sure.
My lord, the judgments of courts of law are not to be taken as Euclid's theorems. They do not set, apart from law laid down under Article 141, they do not set any general inflexible rule. They are dependent on the facts and circumstances of each case. Now, my lord, what has been of pivotal importance in this is Section 400 subsection 8 as contradistinct with Section 400 subsection 1 and subsection 3. Section 400 subsection 8 is an emergency power given to the mayor in council of the corporation, where they can direct demolition without any prior notice to any of the persons affected. Mola Bucks was a judgment, my lord, by which Section 400 subsection 8 had been declared ultra vires. Abid Hussain, in the context of that Mola Bucks's single bench judgment, after setting aside the judgment, held that no, it is something which is intra vires the constitution. Why is it intra vires? Because if a construction is of such a magnitude and such immediacy is involved, which cannot wait for the normal route of natural justice to be followed, then the highest executive decision-making body of the corporation may sit and decide that the demolition can be made without any prior notice. That in the context of that, my lord, paragraph 12 came in. Please have a look, my lord, at paragraph 12 of Abid Hussain. Page 15 of the compilation, my lord.
How can you argue on the basis of their compilation?
My lord, I will, my lord, take a lease from Mr. Mukherjee. Lease from Mr. Mukherjee. Lease. Kindly see, my lord, paragraph 12. It is true that the right to property is recognized as a right of a citizen in the Constitution itself. As my lord, I was placing, my lord, reliance on the first three lines. A citizen may be deprived of such right only by the authority of law. This right to property cannot be construed in abstract. My lord, pausing here for a moment. The deprivation of that right can only be by authority of law. What does the law stipulate in respect of a subsection 1 scenario? Please take a look, my lord, at the statute. In the subsection 1 scenario, the law stipulates a two-tier authority. The first authority, which passes an order of demolition or retention, as the case may be. A second authority, which is an appellate authority, which sits in appeal over the order which has been made by the first authority. It's only after this entire process is over that the final outcome will be available. At the entry stage, one therefore cannot say that this particular process can be nipped in the bud midway. Lord, that's my submission. If one went into the subsection 8 route, there would be no question, my lord, of 1 or 3. Having gone into the subsection 1 route, one cannot then say that after the subsection 1 result is there, it can be kept close to the chest of the authorities and executory consequences can be made without publishing it to the persons who are likely to be affected by it. Lord, the test is any person who is likely to be affected by the action which is sought to be taken. He is a person who's aggrieved for him to carry, my lord, an appeal before the appellate forum. At that stage, the test will be the general test. It will not be the special test. My learned senior friend was referring to the special test of whether any right at all flows from whatever has happened, whether he has ultimately any vested right in his favor. These are questions regarding an unauthorized construction which can be answered after the appellate forum scrutiny is over. Before, for the purpose of getting an entry into the appellate forum, my lord, what is necessary is, if in the general conspectus of things, he has a proprietary right, and where if he suffers a direct affectation of civil consequences, a direct affectation of civil consequences. If he is civilly affected, then he has a grievance, the grievance which he can maintain before the tribunal. It now is within the realm of the tribunal to decide whether there is merit in the grievance and also whether he is a person who could have carried the grievance before the tribunal. That's why, my lord, the 5 judges bench, my lord, which I had cited earlier. Any attempt, my lord, of Mr. Mukherjee to equate what your lordships have spoken in the context of subsection 8 in order to interpret this question, in my reciprocal submission, would be trying to use those judgments as a Euclid's theorem, which judgments of honorable courts should never be used as. My lord, kindly see, my lord, the judgments that have been cited before your lordship. The first one, CMC versus Abid Hussain on 400 subsection 8. Didn't consider section 400 subsection 1 or the right of appeal under section 400 subsection 3. That point was not before that honorable bench. Lord, that's at page 7, my lord, of the compilation. The next one, my lord, at page 18. Please come to page 18. Abid Hussain, my lords, have noted, my lord, that that was on 400 subsection 8. Now, my lord, the next one is Nirmal Kumar Das. That's at page 18. Please see, this was also 400 subsection 8. As the appellant did not stop his construction even thereafter, steps were taken by the authorities under section 400 subsection 8 of the Act. Here also, my lords, were considering section 400 subsection 8. Lord, insofar as the next one is concerned, please have a look at, my lord, page 40. The next one, Czar properties. Please come to paragraph 4. Last but one line from the bottom, my lord. Though notice under section 401 of the Act 1980 was secured and an FIR was lodged under section 401 capital A of the said Act, the KMC authority took a drastic step under section 400 subsection 8 of the Act and thereby deprived the writ petitioners of their right to plead for retention of the construction before the appropriate authority under section 400 of the Act, and further their right of appeal against rejection of their proposed retention prayer. It was also alleged that the KMC authority did not follow the mandatory procedure. Here also, the question involved was whether the authorities had the discretion to initiate subsection 8 or subsection 1. My lords held that if the highest authority has decided that it should be one under subsection 8, the action, then their decision should be respected, and there is no reason why the citizen can come up and ask for a mandamus directing the subsection 8 procedure to be substituted by a subsection 1 procedure. That is not the subject matter of Czar Properties versus Kolkata Municipal Corporation. Now, Lord, kindly come to page 61. Kolkata Municipal Corporation versus Sheikh Mohammed Sharifuddin. There was an order under section 400 subsection 8 which was made. Please come to page 61, the third paragraph. Material facts are that the respondent writ petitioner obtained sanction for construction of a G+4 building, but in fact constructed a G+7 building along with further construction on a portion of the roof of the 7th floor. KMC passed an order under the emergency provision of section 400 subsection 8 of the Kolkata Municipal Act 1980 for demolition of the unauthorized floors. Such order was challenged by the writ petitioner before the learned single judge. Now, my lord kindly turns over and comes to page 61. The learned judge, while recording the written opinion of the mayor in council that the structure in question is extremely dangerous and may collapse at any time, leading to accident.
So, Mr. Banerjee, I believe it would be your submission that all the reported decision as cited by Mr. Mukherjee is in respect of section 400 subsection 8 of the Kolkata Municipal Corporation Act, where the provisions of the section 401 has not been considered.
Yes. Now, my lord, my specific submission would be these were in the light of action taken under 400 subsection 8, where the citizen came up and said that subsection 1 to 3 ought to have been followed. There, my lords have held. Admittedly, subsection 1 has been followed. There has been an order under subsection 1.
Section 401.
400 subsection 1 order. The question is, once that order has been made, whether
your client comes under the purview of aggrieved person or not.
Whether my client, being a person in occupation of the part of the structure, can be considered to be a person aggrieved to carry an appeal before the tribunal, and whether on the assumption that the construction being illegal, therefore there can be no right, the very right under subsection 3 can be completely read down, and it therefore can be held that even if an order of demolition has been passed under subsection 1 and a right to file appeal given under subsection 3, that order can thereafter be kept in the pockets of the corporation and executed straight away against anyone who's affected. That's the question. Now, my lord, this another reference, my lord, a short reference is to the proviso. My lord, kindly take a look, my lord, at the section 400. Subsection 1. Third proviso. Third proviso is a proviso for regularization. Over and above the power conferred by the third proviso, there's a discretion in the municipal commissioner to order or not to order retention.
May, yes.
May.
Oh, no, you said that in connection with the other.
With Rofina. Actually, Rofina and this have been running, my lord, side by side, and very profitably so for me, my lord, as a member of the bar. But just to assist your lordships, my lord, the term may as there under subsection 1 confers on the municipal commissioner a discretion of whether to retain or to demolish. So there it's incorrect to say that if my construction ex facie is not a minor one, although minor thing in the regulation my lord has seen is something which has been kept completely vague. It's incorrect to say that if my construction ex facie does not fit the third proviso, I have nothing to say in the appeal. This is my submission. Please test this. It is incorrect to say that if the construction does not fit the third proviso, then the appellate tribunal will have nothing to do in the matter because it cannot then reverse an order of demolition. My submission is, even if the construction is beyond the regularization compounding scenario of the third proviso, there can still be an order permitting it to remain.
This discretion does not depend on whether it's minor or major.
Yes. This discretion completely depends on the facts and circumstances attaching to every individual case and is essentially heavily dependent on facts, for which there is requirement of a fact-finding forum.
Yes.
At the entry stage of section 400 subsection 3, therefore, what has to be seen is whether I suffer any loss, any adverse civil consequence from the general aspect, in the general broader sense of the term property. Because 300 capital A protection is available to me until the process has been exhausted. It's only after exhaustion of the process that you can say that my right is not protected under 300 capital A.
Would you also say that what is to be seen at the entry door of subsection 3 is actual prejudice? Forget about legal loss or legal prejudice.
Home, heart, possession.
Actual prejudice.
Actual prejudice. The bite more than the insect. Because this is the part of the due process. As I had submitted earlier, my lord, in the Rofina Alam argument also. This is a part of the due process. Suggesting that it can be switched off in the middle is dangerous. It's dangerous. Legislature has very consciously granted a two-tier mechanism. First tier is a tier which doesn't permit everyone to enter, at least from the language of the statute. Only such person. Therefore, the legislature thought in its wisdom that when the second tier is available, then the arena of persons who can make an entry has to be a broader arena.
The legislature could have well said the person responsible, if aggrieved by an order passed under subsection 1,
may prefer an appeal because it was available. So in the same section, those line of judgments again, I've got all the in the same section where the legislature consciously uses two different terms in order to give the subject as a predicate of the right to challenge or right to carry a proceeding, then one will have to construe why it has done so. In my reciprocal submission, the first one cannot be put into the second one because there is no identity of words, no identity of persons. Had that identity been maintained, no one else could have come in.
Anything more?
I would have, my lord, submissions to make. Please permit me to make it any other day.
Made submission on that point also.
No, as far as subsection 8 is concerned, yes. But on 2 or 3 other points, my lord, because Mr. Mukherjee has cited them today, may I just come back and address your lordships, not on any day, my lord, which your lordships may fear. I am ready, my lord, to whatever I had anticipated he would submit. I have got my responses ready. Now that he has put his entire array of submissions, my lord, kindly permit me any other day to just come and complete. It will not take me more than 15 minutes.
15 minutes.
Yes, sir.
চারটে বসে
16. 18 April.
হবে
18 April.
March. Subject
At
to
4 p.m.
4 p.m. Subject to me checking up if some other bench has been
Fixed in the meantime.
Monday. Hey, look now. Mr. Arindam Banerjee, Mr. Vishwajit Mukherjee, learned counsel representing Kolkata Municipal Corporation, concludes his submission. Paragraph. Mr. Arindam Banerjee, learned advocate representing the appellant, begins his argument in reply, but does not conclude. Paragraph lists the matter once again on March 18, 2024, marked 4 p.m, for further hearing. Interim order?
Yes, there's an interim order.
Yes, till
Till
the end of
15
March.
No, till now, my lord, it's still 15th of March or until 15th March.
Paragraph, the interim order that is in operation shall continue till the end of March 2024 or until further order, whichever is earlier.
Obliged, Lordship. Obliged. Sure.
এই সাহেব তো আর বসবেন না তো?